Good morning, everybody. My name's Jeff Horning, and I'm the Association Manager for the Oregon Psychological Association. And I want to thank you all for attending today. Before we kick off everything and I introduce Paul and David, I just want to go through a few housekeeping items for everybody. When you logged on, your video and audio was turned off. Please keep those off as we go through the webinar. It makes it easier for the presenters to be able to present without the distractions of what happens behind everybody's homes. And so we appreciate that. I know there are going to be a lot of questions throughout the day. Please put those into the chat box. There may be opportunities throughout the day where either Paul or David will take some questions, and we'll definitely do that at the end verbally. But throughout the presentation, to help with the flow, please put any of your questions into the chat. I will be moderating those, and if it's appropriate, I will interject in Paul and David's presentation on your behalf. At the end of the day, we will be giving the verification code to everybody that you will be putting into the survey that will go out to you immediately following the presentation. You will need to complete that survey and enter the survey code in order to receive your CE credits. So please make sure you do that. One other note is several of you have only your first name in your Zoom box name, so that we can record that you have been there. Please rename yourself with your first and last name. So with that, a quick introduction of our speakers, Paul Cooney and David Madigan, and our presentation of legal and ethical update. Paul Cooney is a healthcare attorney who has been in practice for more than 30 years. He is a partner at Cooney, and Madigan, where he specializes in healthcare litigation and represents a wide variety of healthcare professionals in all aspects of their practice. Mr. Cooney is general counsel for the Oregon Psychological Association and the Oregon Counseling Association. He represents mental health professionals in malpractice cases, licensing and discipline, and general business matters. He is licensed to practice in both Oregon and Washington, and is a frequent speaker on legal issues and risk management. David Madigan is also a healthcare attorney who has been practicing for more than 20 years. He is also a partner at Cooney, and Madigan, where he represents a wide variety of healthcare professionals in all aspects of their practice. As a healthcare attorney, his practice focuses on defending board complaints, advising healthcare practices on state and federal regulations, including Medicare, HIPAA privacy and security compliance, and data breach investigations and defense antitrust, EMTALA and Stark regulations, as well as setting up group practices. He is licensed to practice in both Oregon and Washington. He is a frequent speaker to healthcare providers on issues pertaining to board discipline, HIPAA private practices, insurance audits, and law and ethics relating to medical and mental health providers, and risk management. So with that, please join me in welcoming Paul and David this morning.
Well, good morning, everyone. Dave is my law partner as well as my adopted brother. So he'll be talking to you about some of the scary stuff today.
Yeah, Paul always leaves the scary stuff to me.
Yeah. It's so nice to present at OPA again. It always feels like we're coming back home for, Thanksgiving, with the family. And you get to meet the weird uncles and the strange cousins that you're only Facebook with, and, that kind of stuff. And so I was watching the names scroll by, and it was always good to see, a lot of the people. For those who don't know me, 25 of my last 30 years of practice I've spent associated with Oregon Psychological Association. We offered as part of our deal to be general counsel is to give a free consult to everyone who is an OPA member. And that is by far one of the most rewarding parts of my job is doing the free consults for people across the state. They're concerned, they've had a HIPAA breach, or they've got a board complaint, or they've got a variety of things, and they just need somebody to talk to. And rather than, having to become attorney poor and pay an attorney to talk about things. And the problem too is that most attorneys don't know that much about mental health law. They know physician law, typically MDs, because MDs have a lot of money typically, and attorneys like money, and so that's a good fit. But mental health, I kind of just jumped into it, and it's really taken over the practice, and in a very good way. I wouldn't change what I do for anything. I can consult for people and just ease their concerns a little bit. And so one of the things we're going to start with just off the top is interacting with attorneys. And it's not something people just normally want to do. And certainly mental health providers seem specifically reluctant to talk to attorneys. And yet that can be a really good source of information. Certainly your own client's attorney, get an authorization if they're going to be involved in litigation, get an authorization to talk to the attorney, a release of information. That's important because they may call you to testify. And if they do, then you want to find out what are they going to ask you. And you can set some boundaries and say, hey, I can't touch on custody or visitation or those types of things, but I can tell you what we've been doing in therapy and why this kid needs stability and those types of things. And so you can set those parameters without having to do that on the stand. And then you can also ask, hey, what is the other attorney going to be asking me? And that's a great source of information. Is their case dependent on making you look like the worst therapist in the world? Or are they just really not too concerned about you? And so getting that information can really help you prepare. Dave is also a great resource for that, talking to people as they're getting ready if they've been subpoenaed. Part of what he does is talk to people and say, hey, this is the things that they might be asking you about. And your safe zone is to always state your source of information. So my client told me this, or the father told me this. That way you're not stating things as fact, it's information you've been told. And so those are good tips to think about before you start interacting with clients in litigation. It's always a good idea to have in your informed consent. Please let me know if you're involved in litigation. It can make a huge difference if the client is involved in a criminal case. They may not want you to talk about the incident in any great detail, just the aftermath and the symptoms and those types of things. But other times in civil cases, it may be important to have conversations or not avoid those things. So find out from the attorney. Let's see. My screen froze up there for a second. All right. So one of the most common questions in these consults, and by the way, for appearing today at this seminar, if you don't already entitled to a free consult through OPA or ORCA or the Oregon Counselors and Therapists listserv, you get a free half-hour free consult with Dave and I for the year. And just pick up the phone, call us at any time, and we will chat with you about it and try not to make you terribly nervous. One of the most common questions we get in mental health is, do I have to turn over my records? I have a request from an attorney or the client or an estranged father or estranged mother. Do I have to turn them over? And these are the various ways that these records requests can come to you. The patient can request it. They can sign an authorization, get a subpoena or court order, health oversight agency like the licensing board or the coroner's office. Now, Dave will be talking a little later about subpoenas and how fun those are. They're just lovely. And so and also the personal representative of the estate. And we'll talk more about that. The days of having a policy that says I don't turn over my records is long gone. HIPAA comes in and you know, God, that's almost 20 years now.
Well, it'll be
2004.
effective, 2023, it'll be
Yeah.
in effect for 20 years.
So HIPAA says individuals have a right to their records. There are some exceptions, and we can talk more about psychotherapy notes. I'm not a big fan of separate psychotherapy notes. They can be confusing, and bottom line is I suggest you have a chart and chart accordingly. Oregon also has a policy. It says individuals have the right to review, access and review their health information. And so there's also issues on regarding access to minors records. I will cover that. There is a new statute on that that changes the way we used to think about that access. And so all of the mental health ethics have something to do with records and access to them. APA is pretty benign about it, just simply says you can't withhold it for non-payment. And it's typically in emergency situations, but bottom line is if the client is asking for records and can't pay for them, you should turn them over. Social workers, you know, access should only be restricted in exceptional circumstances or compelling evidence of harm. That's a pretty clear indication they're entitled to it unless there is going to be significant harm. HIPAA has a similar statute or similar standard that talks about physical harm to the patient, i.e. they might commit suicide, they might be homicidal. It's not mental harm. This may not be good for the client to go through and paw through 10 years of records. And so the standard is typically if you're going to withhold, and we'll talk about it in some more detail, it's physical harm to the client.
Or well, to the client or to some other individual.
Correct. LPCs, LMFTs have the same issues. And today, just for clarity, I'm going to try to cover all of the licenses when there are differences between them. There are some differences. Many of them are very similar, but I'll try to remember to do that. Oregon has a specific statute, 192.558. They may disclose to another healthcare provider for treatment purposes. So if you have a client in common, you can turn over records without the client's consent. And so that's an important exception to I must always get a release. There are many times nowadays, in fact, that's the primary goal of HIPAA, was to increase the transmission and access to records for people, and people often forget about that. But the three great exceptions to getting client consent or client authorization is treatment, payment, and healthcare operations, the holy trinity of HIPAA. And so having a policy, which I still see to this day, it is pounded into people: confidentiality, privilege, confidentiality, don't turn over anything, don't disclose, don't, be hyper vigilant. All well and good, but there's dozens of reasons why people can access records, why you may be turning over records. And so bottom line is, if you're not sure, talk to somebody like me or Dave. And if for whatever reason you don't like me or Dave, we're not smart enough or something, and then we can tell you people that are on a short list of attorneys in Oregon who do understand mental health law and HIPAA and some of the other things that we get into. The way to think about it is you own the physical file. You have to safeguard the file. Dave can tell you some stories about people who didn't safeguard their file. And Dave, why don't you tell your rat story?
Oh, the rat story. Oh, well, I was defending a subpoena. This has been, I don't know, 12, maybe even 15 years ago. And it was down in Benton County, a tiny old time courthouse. But the client had moved to the East Coast. And when the client moved to the East Coast, the therapist, they put all their client records in a self-storage unit. hadn't checked on them for years, gets the subpoena, and finally goes out and checks the record, checks the storage unit, and come to find out rats have been nesting in there for years. And many of the records had been chewed up and made into nests. And so I had to appear before a judge and explain to the judge why the records were not available and they couldn't be produced. So the client was never held in contempt of court because, you know, the records no longer existed in a form in which they could be produced. But I was really surprised the licensing board never took any action over that.
Because you're required to safeguard your records, you know, take reasonable efforts. So the rats ate my homework. Okay.
It worked out one time.
One of the things that I let people know too is if you want your paper records digitized and turned into something that you can store in a fireproof safe or that kind of stuff, my former legal assistant does the scanning. And in fact, she started her own scanning business. Not making a plug for her, but if you want that information, just shoot me an email and I'll provide that contact information. That way the rats won't eat your records.
Right. And if you digitize it, instead of having boxes and boxes and boxes of records that you have to maintain, you might have just a couple of flash drives or a portable hard drive, which you can easily safeguard and access, you know, fairly easily. And it's a lot less expensive to store that than renting a storage unit for years and years and years.
Yeah, and it's so nice. We have, the reason she's good at scanning is we had at one point 4 fairly large storage units full of medical records. We were doing medical malpractice cases for through the Oregon Medical Association and so on, and we just had, you know, to the top of these, you know, 10 by 10, 10 by 20. With no rats so far. We didn't have any get eaten, but we did see evidence of rats.
That was literally 50 years of records.
Yeah, and she scanned them all into, you know, digital form. And if you're looking for a good scanner, by the way, the Fujitsu ScanSnap, I think it's the 1600 now, is a really fast, quick way to scan things. If you don't own one, they're around $400, but they last forever. So that's my plug for Fujitsu. So the Office of Civil Rights, one of the things that will happen if you do not turn over records, and the standard is under HIPAA, you have 30 days from the request to turn over the records or to ask for an extension. And the problem is some people just, you know, the client sends an email, says, hey, I want my records. You say, hey, with a summary due, and then you don't hear anything back and the 30 days passes. The client isn't responsible to come back to you and tell you, hey, this is what I want specifically. Typically, they would sign a release. But bottom line is once they ask for those records, that 30 days is ticking. HIPAA Police, the Office of Civil Rights, has been on a rampage. And so, excuse me. Healthcare providers have a duty to provide their patients with timely access to the records. OCR will hold providers accountable to this obligation so patients can exercise their rights and get needed health information, be active participants in their own healthcare. HIPAA right of access standard requires covered entities take action with access request within 30 days of receipt or 60 days if they get an extension. It shouldn't take a federal investigation to secure access to patient medical records, but too often that's what it takes when healthcare providers don't take their HIPAA obligations seriously. So these people are serious. You need to turn over your records unless there is an exception and you can articulate it. For too long, healthcare providers have slow walked their duty to provide patients their medical records out of a sleepy bureaucratic inertia. I love that language. We hope our shift to the imposition of corrective actions and settlements under our right of access initiative, we will finally wake up healthcare providers to their obligations under the law. Okay. So they're serious. and they back that up with a bunch of settlements. Now, many of these, Office of Civil Rights, and Dave handles a lot of these in our office, they'll reach out and say, hey, there may be a problem. Here's what we think. And you respond back. But these people didn't even respond or didn't send records even after getting that letter from Office of Civil Rights, which of the things that come in the mail, that's one of the scary ones. And they've imposed sanctions ranging from $5,000, it was a 2-year delay of records, up to $200,000. And these are a mix of very large hospital systems and group practices down to sole practitioners. And so they are really kind of hammering away at this. And, imagine getting hit with a $65, $75, $100,000 fine for not sending records because you didn't think you had to send records because it's confidential. Bottom line is you generally have to be on the default path to sending records within 30 days. Talk to an attorney and see if there's an exception that might fit, and then go from there. But bottom line is people do file board complaints, and they do file Office of Civil Rights complaints. And you need somebody like Dave in your corner to kind of work it out. The other thing that they are and have been for quite some time is HIPAA breaches. And so typically the story is there is a lost laptop. It may or may not have some tracking capabilities on it. These are ranging from $1 million to $1.5 million, sometimes even larger than that. And so I'm sitting here on a laptop today. If your laptop is not encrypted, then don't do anything else today, but get your laptop encrypted.
Well,
I have a couple questions.
You bet.
That, want to bring to your attention, just so first, what was the Fujitsu model?
1600 ScanSnap 1600.
How long do we need to keep client records for Medicare folks and for teens?
So for everybody, the standard is 7 years from the date of last service. And so if you've been seeing them for 10 years, it's the date you last see them that you continue to hold on to those records for 10 years. That will cover the Medicare timeline. Dave and I talk often about a 10-year statute of limitations. It's a statute of ultimate repose in Oregon. Generally, after that point, you can't be sued. But bottom line is keep the records as long as you possibly can. If you digitize them, it usually is not a problem to maintain them for a very long period of time. There is no statute of limitations for board complaints. And so I've had them come in, and Dave's had these as well, where they come in, 10, 20, 30, even 40 years. That's the longest I've had after the incident, saying, hey, we had noontime sex as my therapist, that kind of stuff. And so having records can make a big difference. Every now and then it'll kind of draw you into a case that if you didn't have the records, you probably wouldn't be drawn into. But bottom line is save them as long as you can, because they're more often going to help you than hurt you.
What is the most HIPAA compliant way to send records to attorneys?
You can do it a variety of ways. US mail is still kind of the gold standard, even though you can open an envelope pretty easily. But bottom line is US mail is the easiest. Use a tracking mailing system, certified, registered, delivery confirmation, something that tells you that the package got delivered. You can also scan them, and with the Fujitsu, you get the full version of Adobe, so you can add a password to it. And then you can just send it over email. You send one email saying, hey, here's the password. It's Cooney 123. And then you send the attachment encrypted. And that's a pretty good way too. There's also ways through online services, the cloud, where you can typically a retrieval service will say, here's the link, and then you can upload the documents to their link. So there's a variety of ways to do it, but mail is still an effective way to do it.
And then one last one, and then I'll let you get on with your presentation. This is kind of a combo from two different. Do you have to keep notes, records from initial consultations? And conversely, are you required to keep paperwork for people that fail to show or start therapy?
Yeah, good questions. I keep copies of every consult that I have. I learned that early on defending attorneys who didn't have that practice. And having just that initial consultation, here's what we talked about, here's what they told me, here's what my advice was, pretty simple. I can do it on those little carbon things, those phone records deals, and just save those. And if I ever need to find them, I can go back and go through them. But I think it's a good idea just to have a miscellaneous file, throw it in there. You don't need to do much with it. If they never become your client, it's usually not going to be an issue. But every now and then you might have to reach back and say, hey, yes, they contacted me and I never heard from them again. And if you receive paperwork on a client, open a file on it and just save it. Again, if you digitize things, then you're fine. Yeah, I would save those records.
Well, I would just add to that is if they've come to you seeking services but didn't engage with you after that, those records would still be covered under HIPAA because it relates to past, present, or future, which includes just the seeking of services. So you would still want to keep them for that purpose, but you wouldn't need to open a formal file for them.
Correct. And that's good advice. It's treat them as if they were clients because all the confidentiality and HIPAA stuff apply. And so just the safest way to do it is treat them as if they were clients at the time, even though they never became your client. You don't have that duty of ongoing care. Social media is part of the HIPAA enforcement actions. I think in this particular case, it was a $10,000 fine. I think it was a dental office that got a bad review. And then they went on and they decided they were going to expose a bunch of information, personal information about this client. You can't do that. Even though the client goes out there and says, hey, you're the worst therapist ever. You didn't do anything right. You were late all the time. And, I used to have a slide in here with the permission of the person who it was about that their office smelled like cat pee. And I think they said, oh, and you don't wear underwear during the sessions. And so my advice was always wear underwear during your sessions, but you can't go back on social media and say, you were the worst client ever. I hated you, that kind of stuff. You're never going to get better. You were, damaged and so on. Most thinking people don't do that. And so but you're tempted. It's not fair that they get to write this stuff about you. And some of it is untrue. Much of it is untrue. But they don't waive their HIPAA rights by going online and spreading some of this information. And so the best you can do typically is kind of we're sorry you didn't enjoy your stay at our hotel. We strive to be the best and, that kind of stuff. And please contact us if you have a complaint. But that's really about all you can do. You can flag it. I have a handful of clients that from time to time will send me some of their really bad reviews. And if I'm sitting at the coast and I'm a little bored, I start flagging some of those comments just to see how many times it takes for it to disappear. I should charge for that. Yeah. So you got 30 days max to ask for an extension or give a reason for denial. If it's reasonably likely to endanger the life or physical safety of the individual or another person, then you can withhold records. It is not psychological harm or emotional harm. And so that's where people often get tripped up. And I can't say my client it's reasonably likely they're going to be suicidal after reviewing these records. So in a handful of cases, yeah, you can say that, but that is not typically the case. Or it's reasonably likely to cause substantial harm to a person. That's a little more broad, but it is, again, typically physical harm that causes that. And then there is a review process, and Dave and I have both gone through that, and it's not a great deal of fun. You have to go out and get another healthcare provider essentially and pay for all this, and they review the records to determine whether or not things get released. There's also a process where the client can dispute facts or things, entries into the chart. You are free to say yes or no to that review process in terms of, yes, your name is this, and no, you're not schizophrenic, or, but they can ask for corrections, and you need to respond to those requests. Oftentimes you'll say, no, this is what you told me, here's what it is. And then at some point they can offer up a written dispute of all that, kind of like a credit bureau dispute, a couple hundred words of here's why I wasn't late on that payment. But they can, and that goes into their file and must be sent with the file anytime you release the records. If your client passes away for any reason, and no personal representative has been appointed to the estate, that's a process family members would have to go through. These are the people that kind of stand in the shoes of your patient until that process happens. And so it's an appointed representative or a guardian, but typically it's the surviving spouse, majority of the adult children, either parent, majority of adult siblings, any adult relative or friend. And that always seems like an odd one, but bottom line was this was to allow people to have some access to the records. And so if you know that, your deceased patient, Bob, had a very close friend, but didn't meet the other categories, and this is kind of their only remaining family, so to speak, then you might be able to provide some information to them. But bottom line is these people step into the shoes of the patient and can access and release records. And it's whoever is highest on the list that can be found with reasonable effort. And so typically somebody will reach out to you and let you know, hey, your client is deceased. And that may be the person that's going to be the point person. So if it's the majority of adult children, you might say, hey, why don't we designate, Betty Sue to be the contact person if we're going to be having conversations. Oftentimes they're just looking for answers. You wouldn't become their, grief counselor or anything like that, but you could talk to them about treatment. It's difficult to have those conversations, especially if they were estranged. Those can be a little delicate to handle, but bottom line is they have the right to access that information. And so you'll find out pretty quickly if they're blaming you. You might want to notify your insurance company, your malpractice insurance, and say, hey, I've had a client who passed away, who committed suicide. And one of the family members is blaming me, and no claim has been filed yet.
I would just like to add, if you go back, Paul, that you don't take the person's claim that they're in one of these categories at face value. You want some verification they are who they are, and they do have that relationship. So it's just, they can't claim, oh, I'm the individual spouse, and I want access to, to the records. Okay, fine. You were married to them. Can you send me a copy of your ID so I can verify that? But you want to verify who the person is before you provide the information to them.
And don't make the mistake of giving the information to an ex-spouse. That can create some problems for a variety of reasons. So it used to be that the coroner's office would reach out to psychologists and therapists and say, hey, we want your records because we're investigating a death. And unfortunately, the statute back then didn't allow for that. It's a strangely kind of an old language kind of statute, and Dave or I would take the call and say, look, we'd be happy to, but the statute doesn't provide for that access. And so, you know, you can talk to these other people or get a personal representative, or, you know, get a search warrant if you need to, but we're happy to cooperate. But, you know, and that happened enough times. We finally wrote a letter to the medical examiner's office and said, hey, stop doing this. If you want to make it, you know, if you want to get these records, just make a change of the statute. And so thanks to me and Dave, that's exactly what they did. And so now they can access your records if they come and say, hey, we're investigating a death. And so it's always good to consult with somebody about it. We don't get many of those, but bottom line, talk to somebody. So when can you disclose without client authorization under HIPAA, the Holy Trinity, treatment, payment, healthcare operations? If you can get,
what is healthcare operations?
It's everything that you do in your office, from quality assurance to, you know, it's how you run your organization.
Well, and it includes talking with attorneys. So your attorney. So if you contact Paul or me to discuss a patient matter, that's considered healthcare operations under HIPAA. Because it's part of you running your business, and you're consulting with us for a matter related to that. And so you don't need a signed authorization from the client. Now, at some point in time, what you will need from us, with us, is a HIPAA business associate agreement, but not for that initial phone call. I've got a problem. Can you help me?
Yeah, don't hesitate to pick up the phone. And if you're talking to an attorney for your own advice, don't hesitate to call. If we're going to be talking about client information, typically it's de-identified anyway, but it is an exception under HIPAA, as Dave just said. And you can do the legal consultations. Typically, if I'm going to have you send records, I do the business associate agreement and all that sort of stuff, and get the paperwork in place. That's real simple. But bottom line is, you can talk to us. When you send subpoenas to be reviewed, you don't need to cross out the names. It just makes it more difficult. There's a lot of reasons why you can release records. APA has a specific one for permitted by law for a valid purpose. Valid purpose includes billing and treatment and consultations. And so it's ethical too. And then Oregon has their own statute for treatment purposes, healthcare operations. It actually has much of the same language as HIPAA. And so you're allowed to do these things. If you can get a release, get a release, but you're not required to. So if the client is in serious crisis and has just indicated on a call to you saying they're going to take all their meds, and you want to talk to the med provider, do so. It's permissive for them to talk to you, but they probably would under that circumstance. But they're not required to. But that you could call them and say, hey, how much meds does this person have, and what's the lethal dose? And let's get some people, you know, over there and get them helped out. And so you should be able to have those conversations without a problem. And same, you know, same with an urgent situation. You can talk to people in if your client is in crisis, is suicidal, is homicidal. There's different statutes that apply to it, but bottom line is, if it's urgent, you can do pretty much what you need to do, and then work out the releases afterwards. Once the urgency is over, then you need to go back to, hey, I may need a release for this. So this is the APA 4.05, provide professional services treatment. So you can disclose without the consent of the individual, where it's mandated by law or permitted by law for a valid purpose, obtain professional consultations to protect the client, patient, psychologist, or others from harm, and to obtain payment. And so very much like the HIPAA standard. So what can you charge for your records? And we see quite a bit. And by the way, we're going to be taking breaks 10 minutes to the hour. And so just so you can kind of plan your morning, about 50 minutes. So in another little bit, another 8 minutes, we'll take a quick break. And then Dave will come back and talk to you about subpoenas and scare you. So you can't charge whatever you want for records. Here is the maximum under Oregon law. HIPAA says you get to bill your costs. You don't get to make a profit off of it. Oregon has a little bit of profit built into it for the first, $30 for the first 10 pages, but that's basically for you to scurry about and gather things together and shoo the rats away and get your records back together and all that sort of stuff. But it's $30 for the first 10 pages, 50 cents per page for pages 11 through 50, and 25 cents a page after that. You get your actual postage. You can do a summary if the client agrees to it and you let them know what it's going to cost. And I've seen some really kind of outrageous charges for summaries. If it's going to be more than an hour of your time, that's probably a problem. It shouldn't really be that much longer, but there might be some exceptional cases out there, but it's a summary by definition. And so it doesn't need a ton of detail in it, other than, this is what we've been doing. Here's my diagnosis. Here's the things that we've been doing. But it can be helpful to know, kind of what they're going to be using the summary for. But you cannot just say, hey, I'm only going to provide you with a summary and that's it. You have to say it in a way that says, hey, you're entitled to a complete copy of your records. If you would prefer, a summary might be more helpful to you. And that language tends to work, but oftentimes it doesn't. If you get a subpoena for records, a summary is generally never going to work.
I can tell you, the attorney that wants those records will not settle for a summary.
I've heard rumors that there are cases out there, but I've never had one where the attorney said, yeah, no problem. Send the summary, because they're in a court case. They want to see the detail. Workers' compensation is $10 for the first page, 50 cents a page after that. Electronic records has this, $6.50 kind of total sum. If you say, hey, I want to, just take it from your EHR and, dump it over here and send it to me electronically. It's not a maximum, although a lot of people say it is. It's not technically a maximum, but that's about what it should cost you. And if you don't want to go through the price of trying to figure out, how many electrons did I use and, all that sort of stuff, then again, it's not designed to make a profit off your client. I'm a fan of just saying, hey, here's a copy of your records. First one's free kind of thing. Social Security disability requires that. You have to give them a free copy once a year. And so, rather than futz too much about this type of stuff, I would just simply say, hey, that's my policy. Others, they'll charge. I've seen people send people to collections for unpaid fees for their charts. I think that's a really bad idea because it generates board complaints. The client will say, hey, you were mean to me. You didn't do good therapy. And you charge me all this stuff. And if you sue them in small claims court for these low fees that they're unpaid, then they'll come back and say malpractice. You didn't do the therapy right. I don't owe you anything. I'm getting the records to sue you. And so you're retaliating against me for that. And so don't buy that kind of a headache, write it off and, go do something else.
Well, in those cases, I talk to my clients about that and I say, well, let's do a business analysis of this. How much do they owe in unpaid fees? Okay, now let's figure out how many hours of work that you're going to lose to deal with the board complaint, to deal with suing them in small claims court. Because guess what, small claims court, you can't be represented by an attorney. You have to go in and do it. And that still takes time away. And when you start figuring that out, the cost benefits, the costs really outweigh the benefits of, sending your client to collections.
Absolutely. So have a policy in your practice, manage your accounts receivable up front. your ability to see the client. If you don't have language in your informed consent or your office policy that says, hey, one client, you're fully responsible even if insurance doesn't pay. And I can suspend services if you fail to pay and don't arrange for a payment plan. That's your power in that relationship. And it's okay to simply say, hey, we agreed to a payment plan and you're not making the payment today. And so I'm going to cancel today's session. I wouldn't do it if they're in crisis. But bottom line is manage your accounts receivables up front. The worst I saw was, $20,000 in receivables on a case that just got really out of hand. And it can create it's clearly a problem with the therapeutic relationship when the client owes you $20,000. So make some good business decisions. Don't get too much over. They're doing it to other people. I know they're just getting away with it. It's not right. Call me or Dave and vent. Dave loves listening to people vent. He just holds the phone away from his ear and lets you vent. But it's not personal. It's business. So let's take a 10-minute break, come back on the hour, and then Dave will talk about subpoenas.
Welcome back, everybody. Before we get going with Dave and subpoenas, Paul has agreed to answer some of your questions that were put in chat before we get started. So Paul, first one, where can we find information about password criteria to meet HIPAA standards?
Dave, do you know that isn't NIST the one that sets the standard?
Yeah,
They do it for encryption.
It is. They're the one that set the standards for passwords. It used to be the old U.S. Department of Weight and Standards. Now it's branched out into technology too, and you can go to their website and you'll have to scroll through a lot of different stuff to find it. But they do publish a standard. And it's usually, kind of look at the ones where you have to fill out your own password. You have to have a combination of uppercase letters, lowercase letters, numbers, and special characters. And I think it's generally about 9 characters long. It has to be. And usually it has to have one uppercase character in it and one special character.
When it comes to social media, are we allowed to respond at all, even if we're not sharing excessive info?
Well, you can respond, but you just have to be very careful when you do it. And I would probably talk to somebody that knows more about that, because it's easy to let your emotions get a little over, control your fingers on the keyboard. And I wouldn't acknowledge them as a patient. I wouldn't tell them that they're wrong. I wouldn't, there's a lot of things that I wouldn't do. And if you're not going to, which makes it basically not very meaningful to respond, other than to invite them to contact you directly for information. But other than that, and I wouldn't spend money on reputation defenders and some of those types of things. I've had a number of people use those and ended up costing them $5,000, and it doesn't really do much. Things like board complaints and disciplines and that kind of stuff are all public documents. They're going to stay on the web, and you don't get rid of those things. And so it might help get rid of some of the negative reviews, but bottom line is you can invite colleagues typically to say, hey, give me a positive review. And you can balance those out. Instead of a 5 or a 1, you would then have a 2.5 or a 3.
Once the final report is written, do we need to keep the raw data?
I'm a fan of keeping the raw data, and I know the evaluators out there, the forensic people don't like that, and many don't. Certainly if the report references all the records that you reviewed, that can be helpful. Obviously, that's the standard. But if you get a board complaint and the question is about a particular record, it's sometimes very difficult to go then and track down that record. And it may be important in defending your interpretation of it or what it said or didn't say. And so again, if you can just digitize them and save them, I'm a much happier defense attorney defending you before a licensing board. The last thing you want is a very anxious defense attorney going, God, I wish I had more records. Oh my God. We can usually defend them. But if I had my choice, I would say keep the records.
Yeah, I look at it this way, Jeff, is if you've reviewed some other providers' records and you've incorporated that information into your report, then you've actually used those records, and those records really are part of that report. And that's the way I view it.
Yeah.
Does the person who receives access to deceased patients' records then hold the privilege? For example, if another entity wanted to have access to the records, would they need to get permission from the deceased patient's designee?
Yeah, they would step into the shoes. For most purposes, they would be the ones signing releases. And so if another provider wanted those records for some reason, that family person would then sign the release and you would send the records over to that other provider.
Do we have to reply to subpoena from another legal party? How can we tell when we have to respond versus when we need legal consult?
Well, let me put it this way: if it has your name or your business on it, as the person is being issued to, then the simple answer is yes, you have to respond in some manner.
Dave, is it a loophole if they misspell your name or don't get it quite right? Say yes.
No, it's not. It's not a loophole. And just ignoring it is not a strategy either, or it's not a good strategy. Now they can correct a subpoena. We'll get your name wrong. We'll just get it right and reissue the subpoena to you. So that let me put it this way: attorneys, when they issue subpoenas, they're not going to just walk away from that. They're going to follow up on it because they want something. They either want you to appear somewhere, or they want some documentation that you may or may not have.
And we have paid staff that follows up on that stuff. So we're going to get those records.
One last question before we turn it over to Dave for his part. Is there a responsibility to respond to requests from other licensing boards? For instance, if OMB asks for patients' records in the process of investigating a board complaint against the patient.
Dave, you want to take that?
Yeah, you may have to respond to it. The Oregon Medical Board has the same authority as the Oregon, the Psychologist Board, and under HIPAA, they're a health oversight agency, and so there are some exceptions under federal law to providing them records. But before you do so, that's something you really should consult with.
Yeah.
A healthcare attorney that has experience in that area, because there may be, in some instances, there's a way to challenge the subpoena.
Sometimes we call them super secret subpoenas, that they don't even allow you to tell the patient that you're turning over the records. And so talking to somebody in those situations really makes a difference.
Yeah.
Okay, Dave, tell them all about subpoenas.
Subpoenas. Well, I'll tell you what, I've been practicing for over 20 years. And ever since I was just a baby lawyer, my first year, I've been dealing with subpoenas my whole career. I spent probably the first 12 years of my career doing complex civil litigation with Paul's father. And so these were medical malpractice cases, aviation accidents, And the discovery process, this is where subpoenas are generally issued in, can be really complex. And if you don't get it right, then someone can challenge the subpoena. But the other thing is subpoenas, there's no one size fits all. They come in a number of different forms. They all look generally the same on paper, but they all have different jurisdictions, different laws apply to them, and some, have more, I guess, more force than others. And it really, it depends on, what kind of a venue or a jurisdiction it comes out of. So if it's, for example, in the state court system, you can have either a civil subpoena or you can have a criminal subpoena, and there are different standards that apply to both of those. And then you can have subpoenas that are issued in juvenile pendency cases, which have their own standards for it. And so it really is important to know what jurisdiction the subpoena is issued out of and what laws apply to it. And then that determines how you respond to it. And for the last 20 years, the myth, only judges can sign subpoenas, is something I've been trying to dispel. And I still, last week, I had two people say, "Hey, is this valid? It's not signed by a judge." And I said, "Well, yeah." And my response to that question is, judges can sign subpoenas. They have that authority. Rarely will a judge sign a subpoena. What a judge will sign is, if the judge wants records or the judge wants them turned over, they'll sign a court order, which you really have, that's nearly impossible. It really is nearly impossible to dispute.
So tell as many friends as you possibly can, therapists and others, frankly, that a subpoena signed by an attorney can be valid. Have somebody like Dave look at it, but that's really the most common myth we hear is, well, it's not signed by a judge, I can ignore it. And that's just not true.
Yeah. And ignoring a subpoena does have consequences. If you fail to respond to it at some point in time, the attorney is going to get frustrated, and they'll start sending you threatening letters. And then if you don't respond to those, they're going to turn around and file a motion to hold you in contempt. And along with that motion, they're going to request attorney's fees. And, you don't want to get to that point where you have to show up in court and say, well, this is why I didn't respond to the subpoena. And if the subpoena is invalid, and I see a lot of invalid subpoenas, especially for patient records, the simple way to do it is write them a letter saying your subpoena is invalid for these reasons. You have to state the reason why it's not a valid subpoena and you can't comply with it.
And I can say honestly that there are a few attorneys in Oregon that know subpoena law better than Dave Madigan. He lives and breathes it, basically. He knows this stuff. And if he is telling somebody else that their subpoena isn't valid, he typically sends in the rule that he's, citing to, and, is courteous about it, at least in the initial round. But he can be very aggressive if he wants to be. So Dave's your guy. Dave, you disappeared.
Oh, nope, I did.
There you are.
You know what? That's what happens when you use a backup computer. My cursor is just all over the place. So the other one is, I have patients scheduled so I don't have to appear. Well, that's false. You might have to cancel patients for a day because, just because you have something scheduled doesn't mean you don't have to comply with that subpoena and appear where it requests you to appear. Now, oftentimes you can negotiate with the attorney or the attorney's office on the date and I see a lot of this, and I deal with a lot of it with the Department of Justice, is they'll have a trial that's scheduled for a week, 5 days, and they send out the subpoena, which basically says, okay, you're subpoenaed to appear on the 17th of November to the 22nd of November. They're not going to need you every day. And in fact, you know, they only need you for probably about a half a day. And so as it gets closer to the date of appearance, you can talk with their office, and they'll work with you saying, okay, well, we need you actually on the 19th of November. And then you can say is, okay, do you need me in the morning or do you need me in the afternoon? So can we narrow it down to half a day? And that's
Dave, do some of the subpoenas, if they're asking for records and telling you to show up for a deposition, do some of them allow you just to send the records in instead of appearing?
well, yeah, they do. And if the attorney wants to give you that option, send the records in, but you still have to make sure that that subpoena compels you to produce those records. So I know a lot of attorneys will take a shortcut and say, you know, appear with the records because they don't want to take the time to comply with state and federal law on the notice and opportunity to object time period. But you just can't turn records over unless you're compelled to do so.
And that's an important fact too, is if they do it right, they take the right way to do the subpoena, and then the patient or the patient's attorney has been notified and they've been given an opportunity to object, right?
Yeah.
God, I wish I had that button in real life. I could just make Dave disappear.
I'm not touching anything.
It's me.
Yeah, now if they've done it right, the patient or generally the patient's attorney has had an opportunity to object to the request for those records, and they've either done one of two things: they've objected, and that objection has been resolved, or they've waived any objection. And if they object, then that subpoena is really never going to come to you until that objection is resolved. And it may be it gets resolved where they have to go fight over the subpoena with the judge. But once it does get issued, and it's been once again keeps turning me off.
Oh, your sleep cycle's probably set on that. So while I'm talking, you can play around with that power out.
Yeah. But the judge will decide one way or the other. But once it's issued correctly, now you're legally compelled to provide the records. And just saying, you know, it's confidential. Well, yeah, they are confidential. But at that point in time, that confidentiality is waived for minimal purpose of providing it to the party who issued the subpoena.
Now, if I get a subpoena, I'll say I'm a therapist and I get a subpoena and I want to verify with the client that they are okay with me sending the records. And let's say the client says, no, don't send them. What do I do as a therapist?
Well, you know, and that's kind of one of the things that you make a mistake, or therapists make a mistake, is, you know, saying, asking the client, do you want me to send the records? And the client says no. Now you're in a tough position. The client said, you've asked the client, and they've said, no, I don't want you to send the records. But now you have either a court order or a subpoena compelling you to produce the records. So your choice is either comply with the client's request or potentially be held in contempt of court, which you can get fined and pay someone else's attorney's fees, which can be fairly expensive.
So should the therapist tell the client to go have a conversation with their attorney and sort that out?
That would be my recommendation. Say you'll need to go talk with your attorney about this. You know, my deadline for complying with the subpoena is this date. So you've got X amount of time to do something to, quash the subpoena, or I'm going to have to comply with it.
Now, is it true that they only get paid $30 in their mileage?
Well, if you get a subpoena to appear, the very first thing to recognize is you're not an expert witness. You're a fact witness. And as a fact witness, in the state of Oregon, for a civil case, you get a whopping $30 a day and 25 cents a mile. That's all they're legally required to pay you. Now, if a government entity is involved, the fee goes down substantially to $5 a day and 8 cents a mile.
Yay.
Now, yay. And Paul and I talk with clients on a fairly frequent basis about, adding in your fee agreement with the client, letting them know, okay, if you get me involved and in any legal process, whether it's you or it's a third party and you're involved in it, and I'm called to testify, I'm going to bill you my regular hourly rate for reviewing the records, travel, and appearing. And so that's one way to run the $30 a day, is then the client becomes responsible for paying for your time.
Yeah. And if it's not in there, you don't get to charge those fees.
No.
So Jeff, is there any questions before we move on from subpoenas?
Sorry, it took me a second to unmute myself.
Right.
There are a couple. What are some examples of what would make a subpoena invalid?
Well, let me start off with, if the records are from a substance use disorder program, and you really have to be what's called a drug and alcohol treatment program under federal law, unless there's a court order that's already been issued for the disclosure of those records, the subpoena by itself is invalid. If they fail to go through if it's in a civil case, and they fail to go through the process of, and this is in the state of Oregon, they fail to go through the process of the notice and opportunity to object requirement under both state and federal law, then the subpoena is going to be invalid. And then if it's in a criminal case, there has to be a court order authorizing the subpoena. And then the records don't go to the attorneys, they go to the judge for what's called an in-camera review, where the judge reviews the records and makes a determination as to whether they whether they have any value to the case and should be disclosed. But, unless you know these rules, I can guarantee you sitting there scratching your head, okay, did they meet this requirement or did they not meet this requirement? And then you have other ones, workers' comp cases. They have a completely different standard on that under both state and federal law. So it's, like I said, it's not one size fits all, because I see at least one of these categories of subpoenas every week, and oftentimes multiple ones. I generally handle anywhere from 10 to 15 subpoenas a week.
Okay, one more question. Can we charge OHP clients for appearing in court if it is in the consent?
No, you can't.
Question.
And you can't put that in your fee agreement with them. OHP has some pretty strict rules, and it's think of OHP. Well, OHP is actually it's a Medicaid program. Okay, so it's a fairly government funded program, and much like Medicare, there are a lot of things you can't charge the client where you can if it's a private insurance company or they're self-paying.
All right, let's go to practicing across state lines. This is, since COVID came in, this has been my most favorite question to answer. I get this easily several times a week, and there's a dozen variations on it. But here's some general rules that we can talk about is you have to be able to legally practice where the patient is physically located at the time of the session. And so if the client is physically in Washington or Idaho or anywhere else at the time of the session, you have to be able to legally practice there. That means you either have a temporary permit or you're licensed there, or there is some exception to that, or perhaps the client is in crisis. But you don't treat a client in a state unless you're allowed to practice there. And you get a clear answer on that. And then bottom line is, if you're still thinking about seeing that client, go back to rule number 1 and don't do it. The default answer should be no in most cases, and then do some investigation. But bottom line is you will end up practicing without a license in another jurisdiction. And it is the physical location of the client, not the therapist. And so the therapist can be located pretty much anywhere. You're on vacation and you need to see a client who's located in Oregon and you're licensed in Oregon, you absolutely can. It has to be within the scope of competency. The Oregon board doesn't care if you're located somewhere else and you're seeing Oregon-based clients. They still have jurisdiction over you essentially. And so as long as you're allowed to practice in that other state, you're okay. And again, you don't want to get into a situation where you're practicing without a license in that other state. In most cases, it's a crime. And so, and then just because somebody else is doing it, honestly, try that when you're speeding down I-5 and tell the cop, hey, the other people were speeding too, and see how far you get with that argument. Doesn't matter. And so again, your location does not matter. You can treat patients from anywhere on the planet, and call Dave Madigan if you want to practice off the planet Earth, but he specializes in that. And we have people who can help fix that delusion of yours. And the reason this is such a complicated question, sometimes people say, well, it should be relatively easy. And there are organizations, I'll mention them a little later, but in terms of SIPACT and some of the other compacts. But bottom line is there's two considerations is what can I do with this client? What is the practice of psychology or counseling or social work? How is that defined? And then also, what can I call myself? The Title Act. And so can I call myself a licensed psychologist? Can I call myself a licensed professional counselor, licensed social worker? And the Title Act is relatively straightforward. It's the Practice Act. And so distinguishing between what various entities do is a little difficult. And so in Oregon, we have 3 licensing boards for mental health, at least 3. And how they define the practice varies considerably. And so going to another state and trying to understand how many licensing boards do they have, and how do I go about finding out their rules and regulations and how they define it and so on. And then take that one step further and go to another country where the statutes and rules and things are often in different languages, and try to understand. And so my default position is say no, help find the client some resources where they're going to be. And that can be they're traveling for 6 months across Europe. They're traveling for work. They're going to be in 27 different countries in 27 days. How do you deal with that? And bottom line is you didn't create the problem. I know you want to help the client. But bottom line is you may not be able to see that client during that period of time unless they're in crisis. And then you would take the call and talk to them and work with them to try to find something local. Typically, they can find information through the associations. So NASW or ACA or APA has some information on, say, international practice. Do I really need a license in Guatemala? I don't know. But there are ways to find that out there. And then getting resources for people traveling. It can just be, if it's in the United States, it's a little easier just to kind of do a Google search or Yelp or some other rating service. Or you can go to the embassies, and sometimes they have resources for people that are traveling in certain countries. But bottom line is you should help them get local resources. And the problem that I see is the mentality of a therapist saying, but I'm the only one who can help this person. No, you're not. I think I'm a really good attorney. I know Dave's a really good attorney, but we're not the only ones that can help you, say, with board complaints or subpoenas and that kind of stuff. There are other people that can help. They won't be nearly as charming and witty and handsome and all that good stuff, but so be it. Other people can help, and you should understand that. Some states have limited licenses or special permits or temporary permits. Some have a reciprocity type of process. Those can get a little complicated, and sometimes it's just not practical, especially if it's only going to be, say, 30 days where the client's traveling. So, kind of figure it out. And it varies by license type. So for example, in Washington, I know psychologists can get a 6-month temporary permit up there really pretty easily. I think it's only a couple $100 to apply for it. And from what I've heard, people are applying multiple times. If you're a counselor, doesn't apply. And so understand that it makes a difference, and different states have different ways of categorizing people and different names for their license types. And so it just gets very complicated. Person-centered tech, unfortunately, we lost Roy Huggins last year. He was LPC, really great guy, but they're still doing some of the work. I haven't checked recently to see if this map was still up, but they had a map up that had the 50 states and then talked about the different license types and are there temporary permits and are there certain things. And so if that's still up, then absolutely use that. They're a great service. They do trainings on HIPAA for your employees and, all sorts of things. So there are compacts across the states. Oregon, I know the Board of Psychology says they're not going to join SIPAC. They don't believe the standards are up to their standards. And so in the immediate future, that's not going to change. I'm not positive about the American Counseling Association and whether the Oregon board, my guess is it would be similar to the psychology board. They're joined, but they do have different boards. But this is relatively new. I think there's 10 states that have joined, mostly in the Southeast. And then there's a social worker compact that's even newer than the LPC compact. And so this is an evolving standard. Most of the things that allowed for you to cross state lines during the COVID crisis, those have basically been lifted. And so I'd be really careful to say, hey, well, it's COVID, we can go across any state we want. That's just simply not true. Most of those have been expired or lifted specifically.
Paul, we have several questions that are popping up.
You bet.
If I ask some of these?
You bet.
What if a client lies about their current location?
They don't lie. Yeah, I've had calls where it says, oh, I think I've made a mistake. My client just disclosed to me in the middle of the session that they're actually in Alaska. Finish out the session, have the session with them, just document client revealed, middle of session, they're located in Alaska. And then have the conversation with them saying, hey, I probably can't see you while you're located somewhere else. And so some people actually have do an affirmative request at the beginning saying, hey, are you in Oregon? Or they recognize the background for the client, that kind of thing. But if the client lies, I don't know if they're actually telling you they lied and confessing. All you can do is say, hey, we had that session. If somebody doesn't want to pay for it, so be it. But I provided the services. I wouldn't go report yourself to anybody at that point because I don't think you have to.
What if your client is an Oregon resident who is vacationing or visiting a relative in another state and is only temporarily there? Does that mean we cannot deal with their mental health issues that arise while they're physically in another state?
I would love a standard that said, hey, your residency or your domicile is the standard, kind of like for college and some of those other things. It makes the most sense to me, but I have not found any support for that anywhere that says that's the standard. And so bottom line is, if you're not allowed to practice there unless they're in crisis, and you can define that however you wish, but technically you're committing a crime in another state if you're not allowed to see them. So it should be a significant crisis for them, in my opinion, but people will make their own choice on that.
This is I think a little bit of a shift, but does this apply to forensic immigration evaluations, for psychological evaluations for asylum in another state?
I don't know. That's my best answer. My guess is if you're doing any type of psychological service in another state, then that would be required. But if the client is in such a crisis, they need those services, that you could address those to get them the services they needed. But I wouldn't do evaluations. You can get some collateral information from people during an evaluation, in my opinion. If you're just gathering information and they're talking to you, the evaluation is Oregon, the person being evaluated is in Oregon, I think you're okay. Gathering information from other jurisdictions.
Well, what if the client is an American citizen on a business trip or in the U.S. military?
Dave, do you know if the military makes a difference? And I don't think it does, but it does make a difference. Okay. But it also makes a difference of where they're stationed at, and kind of think of the military as it would be like the VA hospital. So the staff at the VA hospital, they don't have to be licensed in the state of Oregon. With the federal government, they just have to hold a valid license from some state. But it takes, it really depends on where's the individual stationed at. Is it, Qatar? Is it Poland? And you really need to, you'll need to look at what the U.S. military is saying about that, whether a private provider versus a military provider or a military contracted provider can provide services to their members. And the answer to that can change from department to department. So it can be different under the Navy, different under the Army, the Air Force. So it's probably easier to do and to get the authorization than for another state.
So you have a client in Washington coming to your office for evaluation. There's no concern since all the work takes place in Oregon, correct? But if you do a virtual feedback session and they're in Washington, maybe that's not okay?
I think a feedback session is probably okay. I mean, I prefer them coming to Oregon just to be 100% safe. Part of our job as attorneys is giving you some options. There are risks associated with those options. And so the safest, hey, I don't want any risk in my life at all, would be to have them come to Oregon for the feedback session. But bottom line is, since you're not really doing any psychological services at that point, you're simply giving them that feedback of a report that's already been written. I think you're 95% okay. But the problem is you go tell a bunch of colleagues, hey, this is what I did recently. And unfortunately, some of them misinterpret the squeal on your colleague rule and feel that they must go report you immediately. And so, just be cautious with it and decide what your risk aversion is. I find most therapists are pretty risk averse when it comes to legal stuff.
One last question for now. I'm a play therapist and work with children. I know my child client needs to be in Oregon for me to see them, but can I have a phone call parent consultation with their parent calling from another state?
I think that's probably okay as well, in terms of you're not doing therapy with the parent. You're simply including them in some information regarding their kid. And I think that can be from any location. Yeah, I don't know of anything that would just say, hey, this is absolutely prohibited. Don't do it. So another lovely, was I going to have you do this or me, Dave?
Which one?
The COVID regulations, the masking.
Oh, you said you were going to do it, but
okay, I'm happy to do
it at any time.
Okay. Another question that we absolutely love is, do I have to wear a mask? I don't make the rules. I'm just the messenger. No, I know people are frustrated by the mask wearing requirements. As attorneys, we can have people in our office on a daily basis, face-to-face, closed room, all that sort of stuff, similar situation as therapy, and we're not required to wear masks. But the way those statutes is written is in healthcare settings, and that includes outpatient counseling offices, behavioral health settings, the whole 9 yards. You're required to wear a mask, and both the patient and you are required to be masked, even if you've got a plexiglass thing in between, you're socially distanced, you have air conditioners or air purifiers and so on. There are some exceptions when people are eating and drinking, or if you happen to fall asleep while the client is talking, you don't have to wear your mask while you're sleeping, apparently. But bottom line is, if you have humans in your office, you need to be wearing a mask. If you're remote 100% of the time at your house, you don't need to wear a mask. Same thing with vaccinations, is healthcare providers need to be vaccinated, or you need to have a religious or medical exemption. The employer will grant or deny that. And they're given pretty good leeway in terms of how they want to apply that. The bottom line is, this is designed for patient protection. The Oregon boards have some good information on their COVID-19 webpage. There's some good frequently asked questions on there. If you haven't been to that, go to their websites and read through that. It's quite good. There is a new rule for the LPCs and the psychologists. It says basically, if you're in violation of any of these health standards imposed during emergency, state of emergency, then they can discipline you. Well, the state of emergency got lifted mostly, but for all intents and purposes, we're not under a state of emergency, but they're still doing this stuff. But the board doesn't need that rule specifically. It can still say you've potentially harmed a client. And so they don't need that specific language to impose discipline. And so bottom line is, if you're in your office not wearing masks and people find out about it, people will report you. I know a lot of people that have reported healthcare providers. I haven't had one of those cases come across my desk yet. I know the medical board has suspended and then ultimately revoked a couple of providers that were not following the mask requirements. There's some litigation going on about that, but bottom line, the board has the ability to do that. You can ask your clients about their vaccination status. That is not a HIPAA violation. They're not required to tell you, but you can have a policy that says, hey, because of my own health issues, I need my patients to be fully vaccinated. Whether the science truly supports that nowadays, given, we're out of date on some of the vaccines and doesn't really seem to prevent some infections, so be it. But bottom line is you can ask that question. And if the client tells you, no, I'm not vaccinated, you're free to say, hey, I offer remote or video therapy. You can require proof of the vaccination. They have the little card. They have digital cards now too. Perfectly okay, not a violation of anything. You treat it just like any other piece of healthcare information they give you. So perfectly okay. APA does, American Psychological Association does have a COVID informed consent online. It's the board's website actually refers to a liability waiver. And you can't use a liability waiver in healthcare. You can't say, gee, client, I'd love to see you, but first you have to sign this waiver saying you're never going to sue me. God, if I could sell those, I'd be a rich man. That'd be great. But you can't. It's unethical.
And Paul, how would a court treat that waiver?
Yeah, it just wouldn't be enforceable at all. It would, and you'd probably get a board complaint for requiring the patient to sign that. And so you don't want to do a waiver. You want to do an informed consent. I take precautions in my office. I do cleanings. I do all these things, but the risk of infection is not zero if you're in my office. And so you're just letting the client know, just much like they go to surgery and say, hey, yeah, we have a clean operating room, but the risk of infection is still there, and we tell you about it. And if you want to continue with the procedure, sign here. And so, and then if your client asks, should I get vaccinated? That's beyond the scope of your license. And bottom line is that, you might deal with their anxiety about it. You might deal with things, you might give them some information, but it should have, .edu or .gov at the end of those websites, instead of something, less credible perhaps. And bottom line is, don't be giving them recommendations whether or not but help them with that conversation, help them kind of sort things out in their own mind, how they want to decide. I think before we get into board complaints and some of that other good stuff, we're going to take this break right now, and we'll come back on the hour. Thank you.
We'll take questions when we get back, just like we did last time. So if you want to put some questions into chat during this break, that'd be great too. Welcome back, everybody. Paul and David, we have a whole host of questions that have popped up, so we'll take a few minutes to ask these. The first one is a pretty basic question. That's what she said, not what I'm saying.
That's very derogatory, Jeff.
Is a subpoena a court order if it is coming from the attorney and not a judge?
Well, subpoenas and court orders are two different legal documents. Okay, so they're separate and they have different authorities. Subpoenas generally are issued by attorneys. Like I said earlier, a judge can issue them. It's generally pretty rare for that, because if the judge wants that information, the judge will order it. Like I said, you can contest a subpoena. Contesting a court order is going in telling the judge, no, I think you're wrong, judge, and you should withdraw your order, which has about a 0% chance of prevailing.
One kind of qualification on that too, though, is oftentimes I get calls from therapists saying, hey, there's a court order that mentions me by name in this divorce proceeding, and says, hey, Dr. So-and-so shall be the therapist. That's not actually ordering you to be the therapist. It's ordering the parties to engage in therapy, and the default is you would be the therapist. but it's effective against those parties in the lawsuit. And so if you get something like that, again, it's a good time to talk to an attorney, because sorting that out can sometimes be a little bit tricky. So just talk to somebody.
Are we required to wear a mask even if we are not in our office while providing services? For instance, home visits or in-person court testimony?
Well, the rules of the court would dictate whether you wear a mask in court. I haven't been over the courthouse recently, so I don't know what the current rules are. You'd have to find out that ahead of time. If you're doing a home visit, I absolutely would wear a mask. It may not technically be required, but if you're doing home visits, I'm assuming that's part of where you normally see clients, at least in part. And so that's the standard, is where healthcare is routinely provided. And if your practice provides in-home healthcare, then I wouldn't see why you wouldn't, just from a risk perspective. But yeah, I'd say you're required to do that.
On the court thing, I think it depends on the county. I can tell you, Paul, I was just at the Multnomah County Courthouse a couple of weeks ago, and they do require you wear a mask at the Multnomah County Courthouse.
Yeah, you'd want to check the local rule for the county you're appearing in. So it may be different in Lane County or up in Umatilla County. The Oregon Supreme Court, they set the general standard, but then they give all the local courts the authority to set standards that may be more restrictive than those set forth by the Supreme Court.
What about walking sessions with clients? Do you have to wear a mask then?
Technically, no. There was a frequently asked question on the Oregon Health Authority's website, and then they've dropped that for some reason. But the example is you're outside of your normal office. And so at that point, you're outside the office. It's generally enclosed office buildings. And if you're doing walk and talk therapy with a client, I would still have an informed consent that talks about COVID, the risks of COVID, and even asking the client, would you prefer that I wear a mask? And if they do, wear one. Bottom line is, it's not only just a professional courtesy to your client, but it's required in some settings. But if you're outside your normal, here's my office, here's where I normally see clients, and for some reason we're over in this other location, generally, that does not require a mask at that point, because that is not where you normally provide healthcare.
I think you kind of answered this question with that one, but do you see having a COVID consent form as still being a necessity at this point?
Yes. I think it can apply to all communicable diseases. I mean, there's a respiratory virus, RSV, going around. There's COVID, there's the flu. I mean, all of these put your clients at some risk depending on their health conditions. And so having a general, hey, if you're having in-person sessions with me, there may be some risks, I think is a good idea.
If seeing clients in person, should we document in our notes that client and therapists were wearing masks?
As a defense attorney, that just, warms my heart that somebody would want to document that and, provide that level of detail, because I am a firm believer that more is more. It helps. And so I would do a little, M&M for, both people wearing masks as a documentation, just to make it quick and easy. Yeah, I would love that.
This one is kind of a technical one, not sure how deep you can go, but can you review or provide resources for managing requirements of confidentiality for substance use or disorders per 42 CFR Part 2 if we have a client with dual MH and SUDs DX with one chart and an integrated treatment plan?
Yeah, Dave does that essentially. We've got a number of clients that have some of those issues going on. And so if you have questions about that, talk to Dave. And if he isn't able to provide the answers you want, he'll refer you to somebody who could.
One last one, and then we'll move on in our presentation. And I apologize, we can't get to everybody's question. There are a lot of great ones, but for time, we have to continue to move forward. But this last one, if we are in person with a client and we are wearing a mask, but they refuse to, can we still have the session? And do we just document, see the client refused to wear the mask? Or do we even need to document the wearing a mask or refusal to wear masks?
Well, if your policy is, and the law is that you're having an in-person meeting with the client and they refuse, I would find out why they're refusing. And then bottom line is you make a decision, but you're not required to see the client at that point. You can simply cancel the session. You can continue the session, but you do so at some risk by not enforcing the mask policy. And so I don't know what would happen if that went to a licensing board or OHA. They'd investigate it and probably tell you to enforce the mask requirements. If it's an ongoing issue with a client, I would simply offer the note that, hey, my policy is that I require a mask, client refused. And it's not that they, just because they have a medical condition doesn't mean they don't get to wear masks. That's not the reasonable accommodation that ADA, Americans with Disabilities, requires. It would be you offer them remote services, or you offer them some other alternative to that. But it's the same as going in the grocery stores with the mask applied there. Just because you have asthma or some other breathing problem doesn't mean that you get to go around and not wear a mask. It means that they will bring the groceries out to your car. They will do online delivery. They will do other things. And so there's other alternatives other than just not wearing a mask. Now, if the client is just sobbing uncontrollably and they need to take their mask off for a few minutes, be human, obviously, and take care of that. But give them something to drink while they're crying or something like that. So they're, technically not in violation, but you can still be human. There's a lot of hypotheticals and there's a lot of things that show up every day that you just have to kind of work through. So we've talked about board complaints a little bit. I'm going to go through kind of generally some of the things that apply to it. And then I'll have Dave kind of talk about, hey, when we have a client come in, here's the things that we ask them to do. Here's kind of the issues that come up, and we'll kind of go back and forth for a little bit on kind of how the board complaint process works.
Well, hey, Paul, let's start off with the easy one, malpractice lawsuits.
Okay, we can get rid of that pretty quickly.
Yeah. So luckily for psychologists, counselors, social workers, there's a very low number of malpractice lawsuits that are brought against these professionals as compared to a medical professional such as a physician or a nurse. So you are more likely to get a board complaint than to get sued for malpractice. And I guess, that would be the good news about malpractice lawsuits. Doesn't mean that they don't happen, but the threshold for prevailing in a malpractice lawsuit against a therapist is extremely high. You have anything to add to that one, Paul?
No, and just remember, you do have insurance coverage for lawsuits. It's $1 million, $3 million typically. It can be higher than that, but that's a good amount of insurance. If we're negotiating a settlement in a case and we want to throw $1 million their way, most people are going to say, great, thanks, we'll settle the lawsuit. But that's the $1 million, $3 million for lawsuits only. There is a separate coverage for board complaints. And so the board complaint coverage is typically $5,000 to $100,000. And if you don't know what that limit is today, you should find out from your malpractice insurer what licensing board coverage you have. If you work for a state agency, oftentimes they do not have coverage for that. They will have tort claims protection for lawsuits, but they do not typically have board complaint coverage. And, you know, $5,000 is just really not enough these days for board complaint defense.
I would also add to that, you know, state or government agencies, if you're working for a large healthcare system, they most likely do not have coverage for board complaint for you. They'll have coverage for a malpractice lawsuit, but not for a board complaint.
And so if you find out you're not covered, buy a private policy. It will protect you, and they're not terribly expensive. And I say that in relative terms compared to, say, our policies. Yours are much cheaper. And so let's talk about board complaints, Dave. How does the therapist know that a board complaint has been started against them?
Well, they finally get notice of it, and it's usually months after the complaint has been made. And you'll get this nice little letter. It'll come from the board. It usually comes certified mail, and it says hello.
Or they use emails.
Well, they'll email it to you sometimes, but they'll always follow up with mail. It will always be followed up by mail because by statute they have to do it that way. Yeah, getting that email generally, you know, is really disconcerting for therapists when they receive it. And it basically says, hey, this is notice that an investigation has been opened up. These allegations have been made against you, and please respond to this in 2 weeks, or, you know, in 14 or 21 days. It just seems to be there's no rule that says how much time they have to give you to respond. It seems to be willy-nilly by the investigators, the time limits they place on that. And so you'll get a very short time period to address the allegations that have been made against you.
So if you get an email with an attachment that's been encrypted that says call the investigator, should they have a conversation with the investigator beyond getting the password?
No. At that point in time, say, yep, I got your email. Said give you a call. Well, here's your password. Is there anything you'd like to tell me? No. Let me read what you sent me, and then I'll respond in kind. And at that point in time, turn around and contact an attorney.
Some therapists seem to think if they have a detailed conversation with the investigator right then and there, it'll make it all go away. They'll understand and just drop it. Does that ever happen?
No. No. Let me put it this way. The investigator does not make the decisions. That decision to open that investigation has already been made by the board. They voted on it, and now they're sending out the letter on it, and the investigator is just collecting information. Some investigators are better at collecting information, or should say more accurate than other ones are. And you really kind of have to be cautious about, you know, talking with them, because you want to make sure you have a record of everything you've said to them and provided to them. So at some later date, they can't come back and say, oh, no, that's not what you told me, or that's not what you provided me.
Now, when you ask for my chart, what does that involve? I mean, does that just mean my session notes and I can just send you those?
Everything. That means your session notes. That means the intake forms. Generally, it doesn't. I wouldn't advise turning over billing records, but if they ask for it specifically, it means billing records. It means all emails and all text messages that you have from that client.
And that's something people often forget to do is provide those emails and texts. And I just had one the other day where I got over 700 pages of emails. A lot of it was duplicative because it's just threads of emails, but you've had cases where, you know, the volume of emails, you know, goes taller than we are basically. And so But it means everything related to that client, because that really helps us see, because how detailed are the allegations that the licensee receives from the board in that letter?
They're pretty general in most cases. It's alleged you have harmed your client. Now, it doesn't say how you've harmed your client. It may not say, what you did that harmed the client. You've just harmed your client. Please respond to that.
And can the therapist assume that it's the client in all cases that has filed the complaint?
No, you can't. In some cases, we can, based upon the allegations, can pretty much assume that the client made it, but sometimes it's not the client.
Will the board ever confirm who filed the complaint?
No, they won't. They won't. I've had cases where, my client, the therapist, thought their client was the one that made the complaint, and it actually turned out that a colleague had made the complaint. So you just can't jump to conclusions about where the complaint came from.
Yeah, it's a little bit of hide the ball, because we never get to know who technically filed it. But bottom line is we still defend it. And we get as much information as we can. They're getting better at giving us more information beyond, hey, you may have disclosed, breach confidentiality. They don't tell you the when, the where, the why, the what, that kind of stuff. And sometimes we can get that from them, but other times. Now, once we send the response in, I'm assuming the board acts on it almost immediately, and we get a response and an answer within a week or so, right?
No. Once again, it will be, and I tell my clients, okay, expect 60 days, 90 days, 120 days before we hear something back from the investigator.
Jeff, do we have questions?
We do, but I want David to finish what he's saying here, and then I'll.
Yeah. So it can be as much as 4 months or 5 months before we hear something back from the investigator. And usually at that point in time, they're asking either for more information or they want an interview with the therapist. And then I was going to say, after that, you think your case will be resolved as soon as that's completed? No, then the investigator's got to write a report, has to submit it to one of the committees. It's usually the Consumer Protection Committee, who will then review it and then make a recommendation, which will then go to the full board. And these things are all done on the board's schedule. So that process can take another 3 or 4 months to go through before a final decision is made by the board.
How do I get charts and records released when I work for a company and the records of the companies and they are not willing to release them?
Then you tell the board, look, I don't have control of the records. My agency or company has refused to do that. I can't provide them. The board has the authority and the power to subpoena, that either government agency or private institution and collect the records that way.
I have a case currently that's been pending for more than a year because we simply can't get access to the records. The board's supposed to ask for them, and then we ask that they provide us a copy with a protective order so that it's all confidential. But bottom line, getting records sometimes is a little bit difficult. And we want the records before we respond because we want to be accurate.
So the questioner asks, we need to save all email correspondence with clients, and what platform would you recommend for text messages?
Well, I mean, the simple answer is yes. All communications you have with the client, save those. When I do that, I generally print it in a PDF format and then save it digitally.
Yeah, you can always right click on, in most email form or servers, you can just right click on the email. It'll say print and print as a PDF. And you just send it, tell it where to, what category or what folder to send it to. But yeah, if it's communication with a client to or from, yes, you have to save those. Those are part of your file. And it's a reminder too to be cautious with your language in emails. I am, a great sinner of that sometimes myself. And, to this day, I haven't regretted many of them, but every now and then you might regret one. And so, but be careful with that and make sure that you're dealing with people. For the text apps, I would probably go to personcenteredtech.com, and they have some product reviews for HIPAA compliant emails and text applications, WhatsApp and some of the others, but you'd want to have one that the client has as well. And so you do want to communicate securely. You can, to this day, it's going to evolve soon. But bottom line is, you ask the client and say, hey, if you want me to communicate by email, knowing that it's not a secure method of communication, please provide your email on the intake sheet. You've told them it's not secure and the client can communicate. I wouldn't send protected health information and have, email therapy with them, but just to communicate about appointments and some of that kind of stuff, perfectly okay. Or use a secure encrypted type of email like Hushmail or Pobox or some of those others.
Is there a recommended amount of malpractice coverage you recommend for board complaints?
As much as you can afford. I mean, I have to disclose my conflict here that it benefits me because it pays for attorney's fees. But bottom line is, I hate having a case where we think it might be defensible, but we need experts and we need people to come in and we need more, forensic stuff to check on phones and texts and all those type of stuff. It can get fairly expensive. And so 25,000 would be the bare minimum, 50 is better, and 100 is even better. It's catastrophic insurance. And so hopefully you'll never need it. But bottom line is, if you're in practice long enough, you're going to get a board complaint. And I've had people with as many as 12 board complaints, all dismissed. But it does happen, and those can be expensive. And typically those are custody evaluations where there's a lot of records to go through, and we have to do a lot of digging.
One last question, we'll move on. I also have an administrative thing. I've tried to direct message someone who is Christie's iPad 2. We do not know who you are, and we need you to change your name so that we can get you your CE credits. But the last question here is, I am producing recorded courses on the topics of my published books. The students who register for the courses are not clients for the purpose of HIPAA or licensing, I presume, ?
Yeah, if it's an educational course, it's not HIPAA protected information. They're not clients of yours. I suppose if you're asking them specific health information, do you have childhood trauma? Do you have a diagnosis and that kind of stuff? Then that could be. But in that setting, typically you wouldn't be required to protect it as protected health information. Okay, let me see here. Not sure what's going on here. Okay. And so, Dave, how often does the board meet to make decisions?
Well, it depends on which board you're talking about, but generally the full board meets every 2 months. And just because they're meeting in a month, at one point in time, and that your complaint investigation has been going on for 8 months, and you've completed the process, and the investigator says, okay, I'm going to get my report done, and you may not make that next board meeting because they set an agenda, and they may have more on the agenda than they can handle, and that case gets bumped until the next board meeting, which is another 2 months away.
So if we're going through the case with the attorney and we realize we've made some mistakes, we didn't have assigned authorization, or we didn't have what we thought we had, and it's actually been something we shouldn't have done. Should we just not mention that and hope the board doesn't find out, or should we bring it forward and talk about the solution?
Well, my recommendation is if you really have made a mistake, then you need to admit that mistake, and then discuss, your rationale for making the mistake, so how it occurred, and what you're going to do in the future to prevent that mistake from happening again. Because the worst thing with the board is to say, no, I did nothing wrong, which I call the Sergeant Schultz defense. And the board says, well, yeah, you did. And, all the records and all the proof we have, clearly show that you've done something wrong, and you just don't get it. You don't get that you have, committed an ethical violation. And so, the punishment that they're going to meter out on that is going to be worse than if you admit that, hey, yeah, nope, I made this mistake. This is why I made a mistake, and this is how I'll prevent it from happening in the future. They're going to levy a lot smaller disciplinary action. You're still going to get disciplined.
What's the difference between a dismissal, a letter of concern, and a sanction?
A dismissal is, we haven't found any violations, we're closing the case. This is not a public record. A letter of concern is, we're not charging with a violation. We are concerned about your conduct here. Watch yourself in the future, because if the same matter comes before us, we will, or we may and probably will, discipline you for it, which is also confidential, and it's not a public record. That's just kept in the board, in your file. And if something like that comes up again, they'll say, okay, we warned you once, we're not going to warn you again. Now, a disciplinary action, that's not confidential, that becomes a public record, and there's no way to get rid of it.
And so if you get a dismissal or a dismissal with a letter of concern, those are two separate documents mostly, should you keep the dismissal letters forever?
Yes, you should, because since you've been under investigation by the board, you will, on your renewal forms, on the attestation questions, have to check the box, yes, have you ever been under investigation or review by a licensing board? And so you're gonna have to say yes, and then they always ask for an explanation. Please provide an explanation of what was going on. And that dismissal letter is the perfect explanation. Yeah, I was investigated, and here's the letter saying the board found no violation, and they're closing it.
Now, since it was dismissed, what if I just don't mention it on my credentialing forms?
Well, if they ever find out about it, now, that will be an ethical violation. And I've actually had that happen with the licensing board. And the licensing board, they check the box no on their attestation question for renewal. And the licensing board 2 years previously, had, issued a dismissal letter. And so they knew, okay, well, you have been under investigation, and now you've either lied or misstated something on your application. And that is something that they will discipline you for. If it's some other entity, it might just be by happenstance they find out about it. But it's not like they can call up the board and say, well, has this person ever been under investigation? The board won't confirm or deny any of that. They'll just say, we can't answer that question.
And so my general rule of thumb when you're talking about credentialing forms is to disclose and explain, rather than just say, no, those 14 arrests that I had really didn't amount to anything, and the board doesn't need to know about that, or they were expunged, or I got diversion, or all those things.
Yeah, policy is, disclose, because the likelihood, it may never be discovered. But all it takes is, to be discovered once, and, you're going to have a big problem.
Now, we run into people that sometimes get very anxious over board complaints. And we have some good people that we can refer to in terms of doing therapy or dealing with anxiety and that kind of stuff. And so if you're having real issues with that, and we're defending you, talk to us about that, because we can refer you to people that are really good and have been with people who have been through board complaints and kind of understand that process. And it can really make a huge difference. It really, one, makes our job easier and makes it easier for you to get through. So otherwise, good self-care. This is up there with death in the family, divorce. Somebody is challenging your professionalism by filing a board complaint. And it may seem frivolous, or it may seem serious, or it may seem made up. But bottom line is, it can affect your career. Dave, what's one of the consequences if you get a public sanction? What do health plans do with that information sometimes?
Yeah, what the sanctions for, but a health plan, they can. A health plan can drop you from the panel. They can terminate you from there. Same thing with your malpractice insurance. Your malpractice, carrier could say, "Oh, wait a minute, you lied on your application. We're not going to cover that lawsuit." That's the last thing you want is, to have coverage dropped. But that can be the consequence. Now, there are certain, and generally, whether they want to drop you from the plan or not relates to the seriousness of the violation and whether there really was any patient harm involved. If it was something like I failed to complete my CEs on that same time period, the likelihood that a health plan is going to drop you is extremely low, or your malpractice insurer isn't going to renew you is extremely low. They're looking at the risk. Are you a risk to patients? Are you a risk to their members?
Now, if you disagree, and let's say the board wants to impose some sort of sanction, they want to suspend you, or they want to revoke you, or they want to do something serious, what's the process? What rights do you have as the licensee to challenge that?
Well, if they want to take some kind of disciplinary action, whatever it may be, they will issue a thing called a notice of proposed disciplinary action. It will lay out their authority to discipline you, the facts that they believe that they can prove that support the charges of the violation, and then the sanction they propose to impose. And then you have a right to challenge that and request what's called a contested case hearing, which is not a fun process. And it's, in my opinion, it's a very unfair process to the licensee. A criminal has more civil rights and due process rights than a licensee does in one of these hearings. Your right to discovery is minimal. The right to be able to examine witnesses is all controlled by the board. So if you want to take a witness's deposition or the claimant's deposition, you have to ask the board first. And if the board refuses that, then you have to go to the administrative law judge who is handling the case and make an argument, a motion, arguing why you should be entitled to depose this witness.
So if we have a judge in there, does that mean the judge makes the final ruling like a jury?
Well, in the procedural matters, yes, they do. At the end of the case, there's no jury. There's just this administrative law judge. They sift through the facts as they see them, and then they make a determination of whether the board has proved their case or not proved their case. And then they write up a thing that's called a proposed order. So it's not a final order. This is just what the administrative law judge is proposing. And then the board can do one of three things with it. They can adopt what the ALJ has said, they can modify it, or they can reject it. And at that point in time, you have some very few options. You'll get a chance to, contest that with the ALJ. And then if you're contesting of that doesn't withstand that, you have the option of filing an appeal with the Oregon Court of Appeals. But then the standard of review with the Court of Appeals is very narrow, and it's extremely difficult to win an appeal of a board's final order.
So what are some of the things that generate board complaints?
Well, multiple and dual relationships, and generally it ends up being a boundary issue. So crossing boundaries with the client is probably, in my opinion, is the #1 generator of board complaints. You either become too friendly, you're sharing personal information with them.
Should the therapist ever enter into a business relationship with the client?
Yes, and that can be a problem too, and it generally is. Anything other than a professional relationship with the client is really a no-no. Because it's always going to be presumed that you exert some kind of additional coercion over the client, whether you did or
right, and you don't actually have to do that. The rule isn't written, thou shalt not, cross boundaries. It's, she'll not exploit and take advantage, and those kinds of language. But if you're defending one before a licensing board, it's often a complex case, a lot of moving parts. And bottom line is, if the client feels harmed by your actions, whether it's, rational or not, you got some issues. What about sexual contact with a client?
that's a never event. So just like the Medicare rule, it's something that should never happen. And if you have sexual contact with the client, you will most likely lose your license. The days of the board, giving you a suspension and having you go through some treatment and then coming back and showing that, okay, I've learned the error of my ways, is way in the past. Their go-to is revocation.
One of the things my father, who Dave and I both practiced under for years, when I first started out, he made me read all the attorney discipline cases, just so you get a feel what people are doing and where they're crossing lines and why the sanctions are. And if it's been a while since you've read sanctions from the licensing board, they are available. Some are easier to find than others, but bottom line is, get used to kind of understanding what people are getting in trouble for. We've already had some psilocybin cases, people kind of jumping the gun on that and doing things. And they oftentimes are really fact dependent. And so it depends on how you approach these things, and how well you document them. And so it's important that you document well for these things. And so some of the COVID stuff, there was no scientific basis for these opinions that these people were publishing. They were very vocal about some of the anti-vax, no mask requirements, and the board just found that there was no scientific basis for their opinions. Refusing to release records. Sometimes you get involved in litigation. They want to bump you out as an expert witness.
These records, Paul.
What's that?
Refusing to release records. What's the most common scenario where that one happens?
I'm not thinking what you're thinking of.
Okay, it's usually with divorced parents, and the non-custodial parent wants the records, and the therapist thinks it'll be harmful to the child client and refuses to do so. And that's when I see, the greatest numbers of that particular issue coming for the board. And unless the father's parental rights have been modified by a judge and taken away, legally, that person has a right to access those records.
Yeah, that's an excellent point, because if we haven't mentioned it before, it's kind of part of the access to records is access to a minor's records. Both parents have access rights. ORS 109 or 107-154 says both parents, custodial and non-custodial, have equal access rights. And so if you're granting access to one, you're granting to both. And even if you're not granting access, they both have the right to access it. And there might be some exceptions. There is some new statutory language that I didn't get a slide on, but let me read that real quick while I've got it up. I'll have to pull it up on another computer. But I'll get to that before we end today. And if anybody wants it, I can send you the new language. Just shoot me an email and I'm happy to do that. But the new statute gives the therapist some leeway when they think it would be not in the best interest of the child to send the records to that person. And it's deliberately loose language. Dave and I have both written statutes in the past, and I don't think either one of us would have written it that way. But it does give the therapist some leeway when they think that the parent has abused or neglected the child, or will in the future even. And so again, the specific language matters, but it's a significant change because our default has always been, when in doubt, send the records, because it's a parent with parental rights. Sometimes when you have a 14 to 17-year-old, they may have concurrent rights as a 14-year-old to consent to treatment. And so who wins when those clash? Let's say the 14-year-old patient says, don't send them. And the parents say, we're the parents, we want them. You generally have to get the court involved. This new statute allows some more discretion on the behalf of the therapist. And so it'll be interesting to see how it plays out. It's a brand new statute. And so
when you say, get the court involved, whose responsibility or obligation is that? Is it the therapist's?
Typically, you'd have one of the parents, the parent who wants to oppose the access by the other parent. You would simply say, hey, I've got a request for records. If you want to object to that, have your attorney send me something saying they're objecting to it or filed a motion. Otherwise, I'm going to be sending records within 15 days or 20 days or whatever it is. And that will generally get something in motion if they're going to object to it. But bottom line is, parents' attorneys know that parents are entitled to the records too. And so now this last one we've had in the past, and I think Dave, you've had a couple of those where somebody was asked about somebody's risk potential. And is this client of yours a risk to their children or a risk to offend? And they haven't done a risk assessment. What trouble can they get into if they make that assessment?
If they make that assessment, and when they do that, the individual that they're rendering this opinion on will most likely be very upset about it, and they'll file a complaint with the licensing board. And then when the licensing board conducts their investigation and finds out that you did not do a risk assessment and you had no basis for your opinion, they will discipline you for it.
And I've seen therapists who are treating one parent, and one of the questions they get asked either on the stand or by me, if I'm just asking them as they prepare for testimony, is this person a risk to their children? Oh, no, they're not a risk at all. They wouldn't harm anybody. And the problem is they've done no background check. And they shouldn't, they're the therapist. And so they don't have the information on past criminal behavior. Does this person have 27 arrests for assault? Would that change your risk assessment? They've been accused of child abuse in the past and it's been founded. You know, all this information that would go into a risk assessment, if you don't have it, you shouldn't be commenting on it. You can say, I've seen them 27 times in my office. They're always well behaved. They communicate clearly. I've asked them about parenting styles and those kinds of things. But making an overall determination on risk behavior in the future is a really bad idea. What about writing letters to whom it may concern? What's your thoughts on that?
My thought on that is don't do it. If you're going to write a letter and you agree to write a letter for the client, it should be to a specific person or entity. So it should not be to whom it may concern. And then the other thing is that the letter should just be factual. You know, so, you know, we began therapy on X date. I've seen them once a week, for every week for the last 2 years. They're presenting diagnosis or my diagnosis is X. This has been the treatment plan. This is the progress or lack of progress they've made. And then this is their current status. That's all that letter should contain.
I have people raise their right hand while they're writing those letters, which slows their typing down considerably, but which is a good thing, because they won't write as much. They should be thinking, what's my message here? And I'm swearing under oath, essentially, even though I'm not in court, somebody's going to use this for purposes beyond what I expect. And so be really careful when you send letters. And then if the client comes in and says, hey, my lawyer wants a letter that says this, take the time and talk to the lawyer. Get it firsthand from the lawyer. Clients are notoriously bad at being able to explain the themes and the risks and all the things that go on in court. They just don't have a good grasp sometimes. And so talk to the lawyer and say, hey, this is what I could say. Would that be helpful? Or no, I really can't say that because I don't have any basis for it. I'm not going to say dad needs anger management because I don't know if all this stuff is true that mom or the other parent has been telling me.
Well, especially if you've never met dad and never done an evaluation of dad, you can't render any opinion about dad just based upon what mom tells you or even what your client tells you.
Right. And so what you would say is the children say dad throws the phone and yells at them and that kind of stuff. And then if true, I'd have concerns about parenting and, you know, that kind of thing. But doing specific recommendations or making visitations specific to that puts you in the line of fire, basically. So let's take another break. We'll come back and Dave will talk about health plans and doing audits, and terminating from them. We'll cover some child abuse or abuse reporting. And then if this is all too much for you, we'll cover retirement if we have time. So come back on the hour.
Sounds good. And put your questions into chat. We'll come out and do about 5-10 minutes of questions right out of the break too.
Okay. You want a lot from me? I'm trying to get it.
Well, welcome back, everybody. And we're entering our last hour. And I want to take a moment to thank Paul and David for all their time on this already. I don't know how one talks for 4 hours nonstop, but they're doing a great job.
You get paid by the word and it really helps.
All right, we'll start with a question. How long am I responsible for my professional conduct after I retire and or drop my license?
Simple answer, forever. You're responsible for your prior conduct forever. Now, when you've retired and you're no longer practicing, well, it depends on the context in which your conduct occurs, whether the board will consider that's disciplinary action or not. Just remember, the licensing board, once you get issued a license, they will have jurisdiction over you until you die.
And even after, there's less they can do to you once you're dead. But yeah, there's no statute of limitations for board complaints. Lawsuits, there is a statute of ultimate repose at 10 years for most lawsuits. But bottom line is, if you know, you have more negotiation ability if you no longer have a license and don't plan to return. Sometimes we can just negotiate saying, hey, I'll never return, kind of thing. But
Should you always have an attorney review your informed consent documents before you have clients sign it?
I always think it's good that you have your practice documents reviewed by an attorney, because you got to remember, these documents, when you provide them to the client, they're essentially a contract. They're making promises of, I will do this or I won't do this. I had one case where the informed consent form said, I will never release or disclose your records without your written consent. And that wasn't true. The records had to be released or disclosed in accordance with law. And the client sued the therapist, saying that the disclosure of the records was wrongful when it was compelled by law. Now, if that client's attorney had read the consent forms close enough, they would have seen that the therapist had made a promise to never disclose those without the written consent of the client, and they could have sued him for breach of contract. So that's just one example of why it's important to have, your documents reviewed by an attorney, and especially one that has experience with either drafting or reviewing these kinds of documents.
yeah, there are a lot of business attorneys that will say they can do these things, and the bottom line is they miss things like anti-kickback violations and that kind of stuff. And so having them reviewed and then reviewing them yourself yearly. What did I learn in this last year that maybe I should tinker with my financial statement in terms of how I'm billing people or those kinds of things. And so they're always a work in progress.
What's the cooling off rule?
So my father came up with this years ago when we were doing Board of Medicine cases, is if you really want to date your client, first you terminate the client formally and you refer them to another therapist. And then there is a 30-year cooling off period where after which you can hold hands for a little while. But that's the extent of it. The Board of Medicine has a motto that says, once a patient, never a partner. And I honestly think that's a good idea, because the way the ethics are written, they talk about timelines, 2 years, 3 years, 5 years. Honestly, it doesn't make a difference, because there's always going to be some influence that you had as a therapist over that person. And you have to prove that had nothing to do with their decision to be intimate with you. And it's impossible to prove.
Are any of the professional organizations pursuing changes in the way the board treats therapists and complaints?
I know Oregon Counseling Association has, and OPA has in the past as well. For example, this last go around, we negotiated with them and we got a lot more detail in the board complaint itself. And so they're writing a lot more detail, which helps us and the therapist defend things. But a lot of it is just administrative law generally, which is, as Dave said, the criminal system has much more safeguards for people going through it than licensees do. And so part of it is having a good relationship with the licensing board and knowing when to, stomp your feet and when to be agreeable. It's a bit of an art. We often pick up cases after somebody has tried a different approach, and sometimes it doesn't work, or they didn't have an attorney. The board is comprised of humans. I know many of the board members, and for the most part, they're all very good people. and it's essentially an unpaid position. And they don't get a lot of thanks for the things they do, but there are things that they could do differently, and they just, decide it's my football, I can do what I want. And that's always an ongoing problem. And the associations always have a very fragile relationship with licensing boards because they have different goals. Associations support people in the profession. The licensing board disciplines people and regulates them.
Who should do a risk assessment if not the therapist?
It depends on the risk assessment, but if it's a risk assessment of saying, "Hey, I'm a client," a risk assessment is more forensic, more objective assessment than it is therapeutic. And so, if you decide your role and don't mix and match them, but a therapist typically doesn't do a background check on somebody to determine the factors in a risk assessment. And so when were they first arrested, at what age, and what were the charges and the severity of the charges, and a variety of other things. You might have diagnostic information, but generally the therapist will not have all that information that's required for a risk assessment. And it is a much more objective role as opposed to a therapeutic role. And so I would never have the therapist do a risk assessment.
This
Well,
last one before we continue on is more of a request than a question. But if there is time, could it briefly be covered what Paul talks about, that more is more with documentation, especially in terms of session progress notes?
Yep, I'll be getting to that. So let's, Dave, let's go into health plans.
Let's talk about more is more with health plans. More is better in your documentation for audits. The more information you have in there, the greater likelihood that you're going to meet the documentation requirements from that insurance plan. And let me tell you, every insurance plan, every panel you're on are going to have slightly different documentation requirements for payment. And if you haven't met those, in their opinion, they can say, "Hey, you owe us a refund. You owe us this money back because you didn't meet the standards that we require." So documentation is really important, and more is better in many different ways, even for board complaints. But this is your financial resources here, and when the insurance company comes to you and says, "Hey, we want to review files for X, Y, and Z members of ours." Think about how many times I've saw them, and how much money might they want me to pay back. It's not in every case that they want a refund, but about 90% of the audits that I've seen, the insurance company has asked for a refund, and you can push back on those. Yes, when the insurance company says, "Hey, send us the records of these members," you're contractually bound to provide those records. You go back through and you look at your provider agreement, and it's going to say, "Yeah, when we asked to see the records so we can do a utilization review," that's what they'll call it, you're contractually bound with the insurance company to turn it over. And then it also fits into that exception under HIPAA. That's payment. That falls in the category of payment, and you don't have to have the client's consent to provide those records to their insurer. And in fact, by joining the plan, they've received basically a contract with the insurance company where they agree that the insurance company can audit their records for the purposes of payment and utilization review. So they have an obligation for the insurance company to get those records. So Paul's got up here top 5 things that are found in insurance audits. The first one is lack of sufficient documentation. And to figure out what documentation you have to have, you'll probably need to, well, you'll definitely need to look at the provider manual. So each insurance company has one, and it's going to have a section on that. And then that section might refer to 4 or 5 different policies, or even a manual that's written by Medicare or Medicaid, or another professional organization that you might have to go look at. And if you don't include each element of information that they're asking for, in my experience, they'll say your documentation is insufficient, and we want a refund for that session.
So Dave, isn't it true that in order to really prepare for an audit, you start at the beginning before you start billing this insurance company, and you find the documentation guidelines and the billing guidelines for that insurer, and to make sure that your chart notes are going to be compliant?
Yeah, that's the way to do it, is when you get that provider agreement, and before you sign it and turn it back in, read through the provider agreement and see exactly what it says. And it's going to have a section on documentation, and then it's also going to incorporate all their manuals and policies that they publish, or sometimes they don't publish. But that contract will incorporate all that information that isn't part of the contract itself, but it becomes a part of the contract by its incorporation. And so, start with, talking with provider services and saying, hey, where do I find, or where do I get a copy of the provider manual? Provider manuals are often available online. And for some insurance companies, you can't get access to it until you're a provider, participating provider, and you have portal access. But at the very beginning, you can ask, okay, well, you guys incorporate all this stuff in here. I'd like to take a look at it before I sign this. So that's the starting point.
If you don't have the behavioral health documentation guidelines from that insurance company, you're essentially flying blind.
Yeah, and so kind of the next 4 things. This one comes up just really often. Not putting in the start and stop time in the session note. It's got to be in the session note. I've yet to see a insurance company that hasn't said that's part of behavioral health. They all have that requirement. And so it's actually the time. Started session at 11:01 and finished up at 11:57. Yeah, if you have that in there, then they can't complain. Okay, well, it's missing start and stop time, and I've seen them reject session notes and say, yeah, no, we want a refund for this. There's no start and stop time. Where clearly, we've had documentation that shows, yeah, that they were on the appointment calendar for this time. It is a 60-minute session. That's what the billing code says. So, the CPT code we billed under, that was for a 60-minute session. And they'll say, yeah, but that's not what we require. We require you to, write down the stop and start time.
So you're saying that the insurance company, after they've paid you, can come back and say, hey, we want our money back.
Yep, they can. They can.
How far back can they go?
Well, private insurance companies, under Oregon law, they can go back 18 months, so a year and a half, but they can go back further if there's evidence, if they find fraud or abusive billing practices. And the term abusive billing practices is undefined. Oregon law doesn't define it, and the insurance companies don't define it.
The lack of start and stop times might be abusive
billing practices. Well, I haven't seen them claim that yet. But now, if you're talking about a federally funded program, they could go back 8 in some cases even 10 years. So it's really important. And I've seen OHP audits go back 6 and 7 years.
So
Because
let me guess, this year for Halloween, you're going to go as an insurance auditor. The scariest costume imaginable.
well, it depends on what party I'm going to.
There you go.
Um, the next one on the list is no written treatment plan, or the treatment plan hasn't been updated. After the start and stop times, that's probably the second number one reason that insurance company will reject that session note. And when they do this, so they may only ask to audit 10 of their members, and then those member session notes for a period of time, maybe 6 months. But then when they come back with their audit findings, and they want a refund, they just don't claim a refund for those 10 members sessions. They extrapolate that out to all the members of the plan that you see and want a percentage back for all of the services you provided those other members, although they've never looked at the documentation.
And you've got to come in and disprove.
Yeah, there are certain arguments about, and it's called a stratified audit. And there's certain arguments that, a stratified audit is not reliable, but it really is kind of a tough proposition to take. The other one that gets people in trouble is illegible notes. If your handwriting, if other people can't read your handwriting, then you should consider having your notes transcribed. Because if they can't read it, they're going to say, well, you haven't met the requirements of our documentation standards.
So we're going to run out of time eventually, but let's go into termination. How easy is it to terminate with a health plan?
It's not difficult, but it is a process, and it can be time consuming. And it is all determined by your provider agreement. Your provider agreement sets out the details or the requirements for terminating from the plan. And, it could take 30, 60, 90 days written notice, and you have to send the notice to the right place. You can't just send it off to, the address that is, okay, here's our contact information. The contract will specifically state where you have to send it. You send the notice, and then you make sure that you get acknowledgement from that address that they received it, and they acknowledge receipt. You want that because that's when your time clock starts ticking. Now, and I can tell you, regions, even when you terminate from regions, you will most likely be obligated to continue to see Regents members that you had been seeing prior to the termination for up to a year, under the same terms and conditions and payment that you were getting from Regents before. So Regents
that's in your contract originally.
Yep.
That you signed. It's a little provision in there that most people don't know what it means, but it has that after effect.
Yeah, and it's not uncommon that the insurance company will have a provision like that where you have to see the members that you're seeing at the time of termination for a period of time under the same payment terms as it was when you're on the plan. And so now once that time expires, you no longer have an obligation to bill the insurance company and get paid their rate anymore. You bill the client. And the other thing is, and this is sometimes people get confused about, is it's only the members that you were seeing from that plan at the time of termination. Anyone anyone new that you take on that is a member of that plan, that continuation period doesn't count towards them.
What if the insurance company owes you money when you're terminating?
Then you make a demand for the money. I mean, you make a written demand. Hey, you owe me this money. And, you know, then, you know, they have an appeals process and you'll have to go through that. And then once you've exhausted these remedies, and that's legally what we call it, you must exhaust, you know, your remedies before you can bring a lawsuit. And at the end of the day, you know, it may be a lawsuit to recover that.
And is there a reason we can't, therapists can't discuss their reimbursement rates on listservs?
Well, that's where the antitrust laws come in, because if you're talking about that with others, then they call it, and you're potentially engaging in price fixing. And
Because the people on the listserv aren't part of a group practice. They're all competitors with each other, right?
yeah, but that's still considered by the Federal Trade Commission as, okay, you're price fixing within that community, because you guys, you know, although you may be individuals, you're agreeing upon what rates to charge, and that is affecting the consumers out there. So, and, you know, technically that's an antitrust violation, and, you know, you could have an AG's office, so an inspector general's office, knocking on your door, saying, hey, you know,
And the same for, hey, we shouldn't deal with Blue Cross or United, or they're terrible and they don't pay well and all this sort of stuff. We should all just drop.
yeah, that's the same thing. You're still engaging in, you know, it's antitrust activities, because a group of people are coming together to either boycott something or to set a price. Now, if you guys are in a group practice, you're all members of the same practice, then it's okay. It's allowed for you guys to, you know, set the price for your practice. But when you're individuals, you can't engage in that behavior without potentially violating the antitrust laws.
So what about, what are your thoughts on somebody who's given somebody a adjustment disorder for 10 or 15 years? Where does medical necessity come into play in terms of audits and those types of things?
Medical necessity is, you know, that is a requirement made by all insurance companies, and definitely Medicare and Medicaid, which is OHP, require that your services are medically necessary. And if you've been seeing someone with an adjustment disorder for 8 or 10 years, then there becomes an issue of why do they need 8 to 10 years of therapy for an adjustment disorder, which is a fairly low level diagnosis? And why hasn't, you know, your treatment of them, you know, been effective in reducing or eliminating this disorder? And as listed on here, you know, the treatment needs to be clinically appropriate in terms of type, frequency, extent, site, and duration. Duration is a big one here, and considered effectiveness for the patient's illness, injury, or disease. And that's what they're really looking at, is duration and effectiveness. But, you know, they'll be looking at all the other things too. But that's what insurance companies will look at, saying, hey, you know, all the professional literature out there says, you know, after a certain point in time, that either the therapeutic approach should be changed, or the services being provided should be changed if the individual is not getting better.
Jeff, you have questions?
Yeah, there's several of them that have piled up. I don't want to take them all at the end.
Ah!
Wait, let me mute myself.
Are the documentation requirements the same when billing out of network? Same if providing super bill?
No, when you're billing out a network,
Oop, what happened? to the-
yeah, my computer keeps wanting to say, hey, it wants to switch from my microphone to the camera, and then it turns the camera off. So sorry about that. But no, you don't have to meet their documentation because you don't have a contract with them, and you're not billing them. You may be providing them a super bill on behalf of your client, but you don't have a contractual obligation to meet their documentation standards. That doesn't relieve you of documentation requirements because there are still professional standards that you have to meet. And if you ever had the licensing board look at your client files, if they find a deficiency, they're going to point it out to you and say, hey, look, our rules and statutes require this, and the professional standard also requires this. But the simple answer is, for insurance companies, yeah, you no longer have to provide that. But the other thing is you have to provide enough information that the client can get reimbursed by their insurance company for the out-of-network services they're paying for.
Is total time spent in counseling sufficient regarding start-stop time?
No, you would need start and stop times in addition to total time. The CPT or the CPT codes are time-based, so more than 52 minutes is the 90837, but you've got to document when that started and stopped. And that's all, again, part of your contract, assuming that it's for in-network billing.
Do we need to ask the clients to re-sign the intake consent forms after 12 months of service?
No. If you've changed them, then that's when you update. And for LPCs and LMFTs, if you change your professional disclosure statement, you have to submit that to the board and then start giving it out to people.
How does, quote unquote, seeing a client for a year after terminating from a plan affect retirement?
Interesting question. Since you get a free consult, talk to us about that after the seminar. We'll chat with you about it.
Which insurance companies are you seeing audit more?
Well, some of them give you a little shot across the bow and they say, gee, we've noticed you're using a lot of 90837. And that's unusual. And that's their term for, hey, we're watching you. And they could audit you and say, hey, why are you doing 90837 for every single client you see? And do they have requirements for it? Do they require pre-authorization? Is it diagnosis specific, complex PTSD, those types of things? Or are there other requirements? It's under the old codes, it used to be the longer code was disfavored and you actually had to show why you couldn't, do all your stuff in 45 minutes. And they've kind of gone away from that a little bit, but they see everybody using 90837 essentially as, boy, we've seen a whole bunch of those and now everybody must be billing fraudulently. And that's not the case, but you need to know from the insurance company what their requirements are for the 90837 code. And if you don't know that, I wouldn't sleep well at night. I honestly wouldn't.
And this is the last one for now, but could you cover the squealer rule?
Squeal on your colleague rule is, well, let me just cover it quickly. It's if you've have reasonable cause to believe that another healthcare professional has engaged in unprofessional conduct or prohibited conduct, you are required to report them to that licensing board within 10 days. Prohibited conduct is basically criminal activity against their clients. Unprofessional conduct has a lot of different meanings or a couple different definitions, but the one that is easiest to know is that they violated the ethics of their profession. And so if you learn from your client that another health professional has violated the ethics, you cannot report that without your client's permission. It is not like child abuse reporting where you override confidentiality. This one specifically, and we were the ones that put that language in there that says, if you learn of it in a confidential setting, you hold it, you don't report. But if you learn about it outside or your client gives you permission, then you go to that licensing board and report what you know. And it's a reasonable cause to know. It's not preponderance of the evidence or beyond a shadow of the doubt or anything like that. It's just reasonable cause. It's similar to the child abuse or elder abuse reporting standard. But if it's learned from your client, now if your client is the healthcare professional who's violating the ethics, same rules is I've learned about it in a setting. Now, if they're doing something, say they're a nurse and they're stealing meds from a patient or intentionally harming people, then there's another reporting statute that says, hey, if they're doing things in the future, a crime in the future, you can report that. You can choose to report it. You can choose not to report it. You're protected from civil liability. We can talk more about that as we go through this. Just very quickly, the 21st Century Cures Act that says, hey, you got to provide people with access to your records, electronic records. That only applies if your healthcare record has a client portal. And so if it doesn't, then that stuff generally doesn't apply. But people still have the right to access their records, just under HIPAA and Oregon law and all the stuff we talked about at the beginning. So bottom line is, write your notes as if somebody's going to read them, and you should be pretty good. Client termination, it's always difficult to break up with a client. Sometimes it's easier than others, especially if you want the breakup to come, then that's fine. But it comes in a variety of ways, angry and threatening clients. Maybe they don't meet medical necessity anymore. I know some clinicians who are very good about saying, look, we're kind of talking about the same stuff over and over again, and that means you're stabilized and we don't need to meet, or certainly not meet as frequently. And so why don't we try a period of time away and see how you do? If the client doesn't pay, you can terminate for non-payment. I would give them a period of time, but you can cancel non-urgent sessions and say, hey, I need a payment. Or they need a higher level of care, and that's often the case. And so document that in your notes that says, hey, I've discussed with the client, they need a higher level of care, and client is resistant to that. But bottom line is, if you continue to see somebody that you've recommended for a higher level of care, you're putting yourself at risk. Because if bad things happen, the client suicides or hurts somebody or does something like that, you could have forced the issue and gotten them over to DBT or intensive outpatient or inpatient. And so document your conversations about termination, even if the client is resistant to it, and don't let the client be the one who holds you in against your will, essentially. I get those calls probably monthly, is I'd like to terminate, but the client's always in crisis.
And then the client's always complaining, that this is abandonment. You're abandoning me. No, it's not abandonment. And especially
they may feel abandoned.
Well, they may not like it, but they're not the ones that get to dictate what kind of therapy or treatment they receive. In the sense, if they don't like it, they don't have to receive it, but you are not required to give them care or treatment that you don't think is benefiting them. Now, getting them into another program, that might take some time. And since the age of COVID, the availability of a lot of programs, there tends to be a long waiting list. And during that time period, you try to manage their care as best you can. But once you can make that handoff, you make that handoff to the to the other healthcare providers. And if the client refuses at that point in time, then you come to the point of, I can't treat you anymore. And I've given you referrals and waited for you to get an opening to accept treatment at this other place. And you didn't accept it. I can't treat you anymore.
And Dave makes a great point about abandonment. I'm doing this 30 years and I've never had a true abandonment case. clients feel abandoned, and they'll use that language because they know that's a trigger word. But bottom line is that's not abandonment. You walk in one day, your client's in crisis in your office, and you say, I don't really like you anymore. Please go away, and I don't want to see you ever again. And I don't have any referrals. I don't have any, anything for you. That's probably abandonment. But people don't do that. Therapists don't do that. And so just because they claim abandonment does not mean it's abandonment. And the board understands that process. Chart as if somebody will read your notes. More is more refers to the opposite of less is more, which a lot of people were trained in school, grad school, or in agencies or wherever they're working at, is you protect the client more by using less information in the chart. It's just very superficial kinds of stuff because this is all very sensitive. Well, all medical information is sensitive, and there are laws and rules that protect it. And you do yourself a disservice and put yourself at some significant risk by not taking more detailed notes. And it's not just, hey, the client, I'm just reciting and I'm a scrivener and writing down all the things the client says. It's think in terms of the SOAP note, the subjective, what's the client telling me is one part of that, but objectively, what am I seeing here? And how does the client present? And what's my assessment of all this stuff that I'm gathering? And what's my plan to deal with it? And so the SOAP note is really good in terms of just getting you to think in terms of what do I need to include in my notes? And this less is more does not protect the client anymore. And all it does is put you at risk. Proving things that are in your document, one of the most used techniques we have in defending board complaints is to quote from your chart note directly. Told the client about termination, all this sort of stuff. Talked about financial issues and, this information. And the worst case that I've seen, well, some people just have no notes, which is obviously wrong. You can't do that. But, 30 sessions on one sheet of paper. Those are not session notes. That's not a chart, period. You're not doing your professional obligation to keep track of what's going on with this client. It will not pass an audit, and it will not pass board inspection saying that's not a note. What's your assessment of them? What's your plan? All that sort of stuff. Suicidal ideation, clearly you've got to have more charting related to that if the client has a history of that. And, it just requires more coordination of care. If you're not reaching out to the med provider or other providers in their life periodically and kind of giving some feedback and coordinating that care, then you're not really doing your job. And so there's a new requirement for continuing education on suicide. And so make sure you take that, consider things like the CAM system, CAMS, I think it is. Can never remember if there's one or two M's. But make sure that you're documenting well, because this could be your last note. And if you don't have anything in there about suicidal ideation with a patient who's been chronically suicidal, that's a tough case to defend. You didn't ask the right questions. You didn't document any of it. And if you go and say, yes, I did, I asked all these questions and they were all okay. Well, the chart is where you put stuff like that. And you wrote all sorts of other things in there about birthday parties and their insurance and all this sort of stuff, but you didn't take the time to write about their suicide risk. Come on. So you should be doing an assessment of that and just articulating why you think it's a low risk. They have long-term plans, they're returning to school, they're happy, they have a new pet, they have a new relationship. All those things go into that. And you've done some sort of assessment. Do a formal assessment of that therapeutic. That's a therapeutic risk assessment, not them going to risk other people. So you can do those kinds of assessments. So maybe I didn't make that distinction clear earlier. And then if you're going to have multiple relationships or potential relationships, something as simple as, hey, I might run into you because this is a relatively small town. Here's how I'm going to handle it. Or sometimes you just make an informed decision to say, yes, you're dying and you have 6 months to live. The rules are probably a little bit different than in terms of, say, I've had people say, I helped the client write their memoir, essentially. We didn't bill insurance for it, but I helped them do those types of things. And so, and remember, you always have the right to withdraw. You should never feel trapped in therapy. So these are just some things that you should be talking about. So abuse reporting. Oregon is a little bit different, and it applies to most healthcare licenses. And the way it works in Oregon, certainly for child abuse reporting, 24/7 requirement. And there's three things that have to kind of come together for you to be a mandated reporter. You have to be on the list of reporters, and all licensees are going to be on the list. There's some exceptions for interns and residents and associates and others, but let's assume everybody here is licensed and needs to be a reporter. So that's usually the one that you meet, and you might have reasonable cause to believe. It's not, I know for a fact abuse is happening, but it's more, I have enough concern that somebody should be checking this out. It's more than just a suspicion, but it's not, tipping the scales even. It's less than that. Probable cause, even less than that. It's around that. And so is my client telling me something that should be looked at? And the last thing is you have to have contact with the child or the abuser. And this is the one that's often lacking. And so if you have an adult in your office who says, I was abused as a child, the question becomes, have I met a child who has been abused? And we've kind of gone around this a bunch of different times, but bottom line is you've not had contact with a child who's been abused. And so I think at that point, you can make a decision saying, I'm not reporting because I've not had contact. And so it's a very common.
And I would make the distinction there. I'm not a mandatory reporter. So I'm a permissive reporter. Now the next barrier you have to overcome in that situation is, does my client give me consent to report? And if they don't, then you can't report it permissively, because you'd be breaking client confidentiality.
And something to remember too is different licenses have different standards. And so psychologists and psychiatrists have a different standard than everybody else. Clergy and attorneys have that same standard, but it's discretionary. They're not required to report if they learn about it in a confidential setting, i.e. in their office in treatment. And so they can use their discretion whether to report or not. And so that's often misunderstood by other licenses saying, hey, no, everybody's mandatory. We know that. Not in Oregon. Attorneys have that same permission. We're not required to if we learn about it in a confidential setting. If you report abuse and you're required to report it in the county in which you learn of it, there's a requirement for an immediate report, but I just got off the phone the other day with a call that they had very little information and they felt compelled to, jump on that, and it said immediate in the statute, and they reported. Now, it turns out they ended up being right, but you can take time to be thoughtful about it. You can take the time you need to assess, is this something I need to report? If you're a psychiatrist or a psychologist, what am I concerned about? In order to report, you do not need to know the names of the people involved other than your client. You don't need to know if somebody's at a continuing risk. You don't need to know half a dozen other things. Did they tell you something and you had contact with the child or the abuser that gave me reasonable cause to believe that they may have been abused? That's go, no go. And if you don't have reasonable cause, then wait. But I would document why you're not reporting. And if you're using the word abuse in your chart anywhere, you should put the pen down and go, have I reported this? And if I haven't reported it, why haven't I reported it? Oh, it's not reportable abuse. I'm just using that word because I like that word. It's a term of art. And so don't use it unless you actually are in a reporting situation. Describe behavior rather than, oh, it's abuse. Dad's engaged in abusive behavior, or mom's engaged in abusive behavior, without describing it. So it's better just to describe it and not characterize it. Because if you say abusive behavior, that means reportable. If DHS or law enforcement come knocking on your door and you have a child's records and they're saying they've investigated a child investigation or child abuse investigation, you're required to turn those records over. They don't get the adult's records, but they get the child's records.
And the other thing is they're entitled to the records. They're not entitled to an interview. And oftentimes they want to interview the therapist, and that may be prohibited due to confidentiality and privilege. So now the records, legally, they're entitled to a copy of those. After that, then you'll have to consider their request and whether you have to comply with it or not.
And if there's ever any question whether or not to turn over records or whether you report, one, I pull up the statute and Dave does too. We pull up the statute every time in terms of reporting, just to kind of make sure we go through all the dot the I's and cross the T's. So get used to reading statutes. Elder abuse, same thing. It's all the same thing. You need the three things to come together. You have to be on the list. You have to have reasonable cause to believe that elder abuse has occurred. The person's over 65, and you have to have contact with the elder or the abuser. And so if somebody's over 65 and there's domestic violence in the house, that's something to really consider. Is this elder abuse? And am I a mandated reporter? And if you don't know the ages of your clients, then you should probably find out. Same type of exceptions for psychiatrists, psychologists, attorneys, and clergy, not required to report if learned in a privileged setting. There's immunity from lawsuits in reporting in good faith. And the developmentally disabled, we see less of this for some reason, but same three elements apply. Do I have in there that must be acting in your official capacity? That's been taken out. So please edit that out. Just cross it off your list. You do not have to be working in your official capacity. This is 24/7. Same three things have to apply. You have to be on the list, a reasonable cause to believe abuse has occurred. And this applies to people adults who are disabled, who are eligible to receive services through a community mental health program or agency, or will be. And so large group practices are often community mental health programs, like Western Psychological or Life Stance. They're part of that. And so they would be mandatory reporters for people who have mental health issues. And so it broadens the definition quite a bit, and can be where you normally not think about reporting spousal abuse because it's not a reportable event. In this situation, they might qualify under that depending on what location you're providing those in. And so just kind of be aware of that it's a pretty broad category. If you're working for community mental health, it applies to basically everybody with the chronic mental health issues.
See, and that's for kind of, the chronic mental health issue doesn't have a legal definition
Right.
for the reporting statute. And that's definitely, it brings into question does this person meet that definition or not?
And they've been tinkering with it for a while. And so it's helpful to have somebody that can actually go through it and read it and, kind of understand that. Spousal abuse, if there are children present, then it is likely going to be a reporting issue. But otherwise, it's not a reportable offense. And that's something that should be changed perhaps. And so there's two ways to retire. If you're scared now of all the audits that are coming and all the lawsuits that are coming and the board complaints that are coming and oh my, and lions and tigers and bears, we will protect you, one, and two, you can just die and you're officially retired. People do die unexpectedly. They have medical emergencies, they become disabled. All sorts of things happen rather quickly. And bottom line is you have to kind of, if you're still living, you have to do the best you can. And so call on colleagues. Typically, every license has a requirement that you have to have a designated person to take over your practice in case you become incapacitated. And so that's the time to call that person and say, hey, I have a serious medical issue and I can't continue to see my patients. We're going to need to transition them. And so you get on the phone and you start sending emails and you start taking care of things. You change your outgoing message and you explain as best you can. It's not an abandonment issue if you're physically unable to provide these services. And so, and you may need more than one colleague to help you out. And so if you don't have a professional will, that's something to consider is what happens to all my professional stuff? Where are all my passwords kept? Where are the keys to the safes? Where is, all my passwords and everything else? And, can they use my thumbprint after I'm dead or, whatever, that kind of stuff. There needs to be a way for people to get in to access things. And so you can help the people out by having that planned out already. Now there's the more planned way to retire things. And Dave, you want to go through some of this?
Yeah. Well, you want to notify your clients in writing. That'll be, retiring and give them a time period. 60 to 90 days is, that's sufficient. Oftentimes, I've had clients that have given longer periods, 6 months or even a year, because there's a planned retirement. They already decided, this is my stop date. When you give those notices out, make appropriate referrals for that client. Let them know, hey, you're going to have to transition to someone else because I'm going to be done here in 6 months, 8 months, whatever the time period is. Notify health plans that you're on, that you're going to retire. And oftentimes, if you retire from practice, those provisions about having to continue to care after the termination date don't kick in. So there are some exceptions to those. Contact your malpractice carrier and find out, and this is the most important one, do I need tail coverage? And tail coverage is an insurance term because you might need to buy a separate policy to cover the time period that you basically cover the 5 years before your retirement or 10 years before your retirement, continue on for another period of time. Because if you have a claims made policy, it's the insurance coverage that you have at the time the claim is made, which determines whether you have coverage or not. And if you don't have a current insurance policy, then you probably will not have coverage for that claim. And if it's an occurrence policy, then it's based upon the date of the claim, of the incident. And then it looks at what policy was in force and effect at that time. But it's really important that you do that, or you may be retiring what we call bare. You don't have any insurance coverage, and if something were to come up, it all comes out of your pocket.
We've got only a few minutes left, and I want to get to Jeff's questions. Because we're interactive, we need to answer the questions. So this is all pretty self-explanatory stuff.
Yep.
Jeff?
All right. We've got about 10 questions that have popped up here, so we'll try to make them quick. Would sharing reimbursement rates of different insurance companies among a small group of clinicians, say less than 5, is that considered price fixing?
Technically not. You have to have some level of market share, but bottom line, it's just risky behavior. I generally wouldn't do it, but I don't think anybody's going to come knocking on your door. It's when you get the listserv and you have hundreds of people sharing that information and they're all competitors in a market area. You have to have some control over that to be able to control the price fixing, and a group of 5 people isn't really going to qualify for that. But yeah, it's just not a great idea.
Why don't insurance companies support 90837? Why do they see this as a concern?
They're insurance companies and they're evil. They see you all as just a bunch of little overutilizers out there going, hey, we want money. It's just kind of their view of the world is that you should be able to do things that you did back when you were, 90808 and 90806. People were able to do it, and now everybody's billing 90837. And it pays more, and so generally it pays more. And so they just see that as upcoding. And I don't see it that way. If APA and OPA and others have kind of joined in and said, look, that's not the way it is. You guys set the policy in terms of how long this time code is. Don't like it, change it. Turn it back to 45 minutes or something. But we're seeing people for 55 minutes. We're good.
If OHP does not pay because client has a second insurance and the second insurance is not paying either, can we charge the client?
I will decline to advise you on that because I hate Medicaid.
If the client has a separate policy, insurance policy from OHP, and it's the same thing with Medicare. They by law are secondary payers. So if there's another payer out there, that payer has to pay first. If they don't pay, then it really comes down to the client having to do something. But you're still bound by the agreements with Medicare and OHP about billing the client, whether there's a secondary policy in place that should pay first or not under the federal laws. So
It
the simple
depends.
answer
Is the service not? It depends. If the service isn't covered, then you could just say, okay, the second one denied, and I'll submit it to OHP for secondary insurance. But if you did something wrong, or they denied it for administrative reasons of some sort, that's not technically not covered, or they haven't paid, and so they haven't completed that loop, and so you can't submit it to OHP yet.
All right, you two, we're going into the speed dating of questions. Keep your
You
answers
bet.
short.
Yes. No.
If you are raising your rates and give 3 months notice and client says they cannot afford your new rate, can you discharge if they will not accept referrals?
You can discharge for any reason at any time, giving them 30 days time.
Notice and referrals, and then you can discharge.
Your job is to give the referrals. You can't force the client to take them. That's the client choice.
How about closing a client for having 2 or more no-shows or late cancellations, including OHP?
Yes, you.
Form consent form or office policies saying, hey, if you're a no-show this many times and I don't hear from you, you'll be terminated as a client, and then they're on notice. What is your policy?
You cannot charge no-show fees to OHP clients.
So if a client tells you about abuse, they know about it. You don't have to report it because you're not in contact with the child or abuser.
Yeah, let's say mom comes into therapy and says, I'm pretty sure my ex is abusing the kids, and you've never met the kids or the ex. You're not a mandatory reporter at that point, period. Now, if mom wants you to report, I would encourage mom to report because she has the firsthand knowledge. And I would, sit there with her. And if you can get somebody on the line quick enough, do it while you're in session. But yeah, you wouldn't be a mandatory reporter if you just hear about it and it doesn't involve the person that you're talking to.
All right, that takes us up to 1 o'clock and the end of our presentation. I know there were probably another dozen questions there, and I don't want to have to keep Paul and David here till 2 o'clock answering them all. I'm sure with part of your consultation, they can answer some of those.
Yep.
But thank you, everybody, for your time. A huge thank you to Paul and David today for their time and efforts. A survey should have gone out to you already. It should be in your email box. The verification code at the end of that survey is OPA 1028. I'm going to put that in chat right now, so you have it. It's there.
Thank you,
OPA
Hank.
1028. And if you have any final questions or anything, contact the OPA office. Our next presentation will be on November 18th from noon to 1. And we have members of the Oregon Board of Psychology to talk about COVID and all sorts of other things. So that's a free webinar to OPA members. So if you're an OPA member, you can get on and chat with those OBOP participants. So
Thank you, everybody, for coming today. We really appreciate your support. We love what we do. And so it's never a bother for you to call us up and make an appointment, or send me an email. If it, either one works fine with me. And just get your questions answered rather than fretting about it. So hope we can help out.
all right. Thank you, everyone.
Thank you.